this time, we want to recognize that there is certainly some Caribbean American delicacies that are in the conference room. Please, Ms. Myers, Mr. Myers, take some with you, because I know Vincent doesn't need any food to bring with him, but we don't want any additional legislator programs that have to be put out for the delicacies that are out there today, especially after the afternoon luncheon. At this time, I'd ask the Honorable Majority Leader, Pete Harcum, to come down for purposes of the next presentation. Mr. Harcum. And Mr. Ryan. I'm sorry, Mr. Ryan.
Thank you, Mr. Chair. At this time, I would ask the members of the Westchester County Technical Rescue Team, Commissioner John Cullen, Chief Pete Patacco, if you'd all come down front, please. And to begin our presentation this evening, I'd like to introduce my colleague, Legislator William Ryan, who's been so instrumental over the years in the formulation and the strengthening and the growth of the Department of Emergency Services. Bill?
Thank you, Pete. Well, good evening to everyone. Probably about 12 years ago, events in this county required that the Board of Legislators take a real careful look as to how communities from north to south and the Hudson River over to Connecticut, how all of us as a community, a county community of individual county communities were responding to emergencies. And like I say, it was about 12 years ago, and it was at a time when some very serious occurrences, serious events caused us to take a real careful look at this. What we determined was that we had certainly a role to provide at a minimum what's called coordination with respect to mutual aid. It's a system of response. It's a system of reciprocal assistance, where one community will help another without question, knowing that the very next day they may require help from the community that asked them the day before. That's simply put. The long and short of it is that this board decided that we needed to formalize emergency services in Westchester, and what we did was we created the Department of Emergency Services, and that actually was done in 2000. In 2001, that young department embarked on a very important mission, and little did we know that its very first test would be to coordinate resources on 9/11. Because of the disaster that occurred with the attack on America and the destruction of New York City's emergency management operation. And so many of the gentlemen you see here tonight, our great commissioner, John Cullen, was developed and trained right here in White Plains, and he with others from White Plains and other communities in Westchester played an important role in how we regionally responded to the great need of the city on 9/11. But the department certainly was tested that day and came through with flying colors, and we were now very intent on making sure that they had the very best with respect to technology, computerization of the system that would allow us to be effective in our role as mutual aid coordinator. The marshaling, the overseeing of a system of resources, in particular fleet management, all different types of things led by an individual who would be elevated to the commissioner level. We had a number of excellent commissioners, and Mr. Cullen shows that that string just continues with him currently serving as commissioner as our new commissioner for a relatively brief period of time compared to the life of the department thus far. During the time that we were looking at the services that we would help communities provide, we recognized that localities had the responsibility to provide an adequate first response to fire and EMS and hazardous materials situations. But we were in a new era, and new things were coming to us, such as how we would respond, help communities respond to radiological and biological and chemical weapons of mass destruction. Those agents certainly posed a threat to us. And while we were doing all of the things that we thought we should be looking into and developing to ensure that our department was the best it could be in complementing local efforts, we had a great group of Westchester first responders, a mix of people. Some came out of fire, some out of EMS, some out of police, who introduced us to technical rescue, high-angle rope, trench rescue, a whole new discipline of things. And this legislature went and talked to these very knowledgeable, trained individuals about their great idea, not ours, their great idea, to supplement what was being offered by Westchester County through its brand new department with this new discipline, for us new, technical rescue. And some of those individuals that introduced us to all of this well over a decade ago, probably at least 9 or 10 years ago, are here with us tonight and are part of Westchester County's Department of Emergency Services Special Operations Technical Rescue. Their great idea that they brought to us as a legislature, and they assisted us in pushing the issue to make sure that our department would be modified in a way where we would have this. And what a sales job they did. They sold they sold the idea themselves. We were in a special position as legislators to do some of the legal things that had to be done, the laws, the budgeting, but they sold the need and demonstrated what they would be capable of doing. So I provide that as a background. It's part of the valuable inventory of specialized services that we as Westchester County provide through the Department of Emergency Services. All the legislators in this room that were present back then played a role in forming that department and bolstering it in a way where it could be so effective. And then, of course, we play the waiting game. Will they be called upon to actually go out into the field and accomplish the things that we want them to accomplish? Well, we knew that that would certainly happen. We didn't know when, but we would be ever vigilant and prepared. We knew it would happen at some point. So here we are today, brought together for a very, very important occasion that focuses well-deserved attention on this group. And what I'd like to do at this point is turn this over to our majority leader once again, Pete Harcum. Given that history, Pete is going to take you through the reason why we're here tonight with this great team.
Thank you, Bill. I neglected to mention this evening, first of all, when the chief and the commissioner came down, team leader Tom Bach. Tom, apologies for the oversight. I was going to get to you, but there's one person we really would like to acknowledge. We talk a lot about public service, and all of the members of this team embody it in their daily lives. They walk the walk, they just don't talk the talk. And we were trying actually to get a Skype feed to Bagram Airfield, where Brett Schlosser is in the 411th Engineering Brigade, serving us in another uniform as we speak right now. So we're very proud of him and appreciative of his service. And what Bill was alluding to was the team was just recognized nationally for heroism. Back in August 28th, you remember all of us were scrambling to serve our constituents and deal with the damage of Hurricane Irene. And unfortunately, some people thought it would be a great day to go whitewater rafting. And unfortunately, that was a fateful decision. It cost one person their life, actually one of my constituents, and it could have cost many of these team members their lives. And the remarkable thing about these individuals is we have a fight or flight instinct in all of us. And when there is danger, 99.99% of us, our instinct is to flee. And their training tells them to go, whether it's a burning building, whether it's a trench. In this case, it was a swift water rescue, which the experts will tell you was among the most dangerous kind of rescue there is. The team put their lives at risk. Unfortunately, there was one fatality as they arrived on scene, but they were able to save a number of other raptors, and they all came out alive themselves. And that's part of the miracle of their training, is that not only did they bring the civilians out alive, but they came out alive. So we are very proud of you. We are enormously grateful for your service, your training, your professionalism, and you know, we deal a lot, over 6,000 line items in the budget, and when we can look at the human faces of the logistical support in the building, and the commissioner, and the chief, and all the support services, and the faces who are out in the field that day and saved lives. It's Tim and Richard and Thomas and Joseph and Chris and Fred and Carlos and Paul and another Chris and Mark and Robert and William and Phil and Nikolai and Elliot and Gerard and Terrence, Jerome, Joseph, Doug, Richard, Brett we mentioned, and Albert and the chief and the commissioner. On behalf of everyone at the Westchester County Board of Legislators, we applaud you, we honor you, and we thank you. God bless. Thank you.
Thank you, Chairman Jenkins, Public Safety Committee, Attorney Meehan, the board, Peter, Commissioner Cohen, Chief Patako, invited guests, and fellow members. They always say that we'll save the best for last, and the group that we would like to thank the most is our families, because they tolerate everything we do, and they tolerate it very well. They're the real heroes, and we thank them. Back in the year 2000, Rich Banquet had a vision for the County Technical Rescue Team. We shared this vision with Rich, and myself, Tim Fisher, and Jerry McIlvain brought the dream to reality. We held numerous meetings with two county legislators, former county legislator Richard Wishney, who unfortunately is not here tonight, and current legislator Bill Ryan. And we thank them for their help and their understanding, and they were committed to us and our cause the entire time. As mentioned, one member is not with us tonight because he's in Afghanistan, and try as hard as we did, we just could not connect with him overseas. We pray for Brett and all of our troops' safe and speedy return. We've consistently told the county if they provide the equipment, we will provide the personnel at no cost to the county, and we've done that, and they've done their end. Tim Fisher always says if we only save one person, it would all be worthwhile. Well, we've saved more than one person. It is worthwhile, and we'll be here to proudly keep helping Westchester's residents and guests whenever the need arises. Thank you for your support and this honor.
Double level.
Mr. Tall is back. Back there. That's a default protocol or anything like that. 1, 2, and the other 2. So, stay here. I like this going on here. Okay, right here, 1, 2, 3. One, two, three. Last one. 1, 2, 3. Count right here.
Congratulations.
Another round of applause for an outstanding technical rescue team. At this point in time, Mr. Harcum, for the minutes approval.
Thank you. Would you care to do the consent first?
Let's do that one first.
All right, let's do that. I would move this with actually a number of proposed modifications. Let's start on page 5. Items 4 and items 5. Remove Committee on Government Reform, Efficiency and Savings on both items 4 and 5. On page 7, 12, 13, and 14, sever those items. On page 7, at the bottom, number 1, please add Legislator Testa. And then, on page 9, item 11 at the bottom, continuing on the top of page 10, replace Committee on Legislation with Committee on Budget. Number 12, we are adding basically the entire Democratic caucus to save time rather than name all the names. Number 13, sever. Number 14, please add Committee on Legislation. Number 16, replace Government Operations with E&E. And number 18, please add the entire Democratic caucus. Is that everything?
Mr. Mazzano. Mr. Williams.
I'm in agreement.
Number 19.
I think it's number 19, not 18.
Which one?
Last one. Okay.
Number 19. Right. Those names should be added to number 19. Apologies if I misspoke, and thank you to my colleagues for catching that.
Mr. Mazzano, with that correction on number 19?
Mr. Chair.
Item 14, we're going to separate from the agenda as well. We're going to separate item 14 from the agenda as well. On the items that were separated,
Those would be overed, all of them?
thank you. Mr. Harcum, on the minutes approval?
Yes, would you care to entertain a motion before the minutes approval as an amendment to an item that we have a public hearing on very shortly, and we need to make the amendment to before the public hearing, which would be local law amending section 700.28 of the County Fair Housing Law. And we have a proposed amendment from the County Attorney's Office that the two caucuses have discussed. I would care to offer the amendment to the Chair of Legislation, Chairman Ryan.
You're in order at this time.
And the change would be, the change to the law is on page 3, section 2, subsection A.2. The previously signed out legislation reads, if an election is made under this subsection, the Fair Housing Board shall authorize the county attorney to commence and maintain a civil action on behalf of the complainant or aggrieved person on whose behalf the complaint was filed. The new amended legislation reads in the same section, if an election is made under this subsection, the Fair Housing Board shall authorize the county attorney to commence and maintain a civil action on behalf of the Fair Housing Board, naming the complainant or aggrieved person on whose behalf the complaint was filed and the respondent.
Mr. Ryan.
Just a note on context. The members know the Legislation Committee has been dealing with the requirement that we be in a state of substantial equivalency with okay, that's very good. Okay. So anyway, in our work, we're attempting to achieve substantial equivalency, a certification that takes place when we as a local agency apply for it, in this particular case because we benefit from the program that HUD operates, the Fair Housing Assistance Program. That work has been ongoing, and the committee reported out amendments to our law that would represent our final product for consideration by this board, and because considering it and passing it, we would be viewed by HUB as having achieved this substantial equivalency between our local law and the federal law. So that report, the board's committee took a vote. That report has been made, and it's on our agenda tonight. The amendment that Mr. Harcum has brought up this evening was presented last week. It was published by the board on Friday to give people an opportunity to become familiar with it before the hearing night, which is tonight. And in reviewing the amendments, I accept them on behalf of the committee, and I'd also mention that the version that we are going to be considering at the hearing and then at a subsequent date by a vote of the board also specifies that the county attorney, in representing only the Fair Housing Board of the county, it's stressed that the county attorney has no attorney-client relationship between with the complainant or the aggrieved person. So I just add that as filling out the entire piece. The language that the majority leader has offered tonight is accepted and substituted now for the language that appears in the version that the committee reported to the full board for our consideration.
Thank you, Mr. Ryan. Mr. Mazzano.
I just gave some information about this change to the majority leader, and we think it might be helpful to hold a 1-minute recess in place to discuss one matter with the leadership.
On this particular matter,
Yes.
Mr. Mazzano?
Yes.
All right, we're in a recess in place. Mr. Mazzano, at the call of the chair. We're at a recess on the call of the chair. We are back from recess. Thank you so much for the understanding. At this particular time, Mr. Harkin, we are at the time, did we do minutes approval? I cannot remember now.
No, we didn't, Mr. Chair.
Thank you, let's do that.
We've been bouncing around, I realize. At this time, I would move the minutes of the Monday, May 21st meeting that was held at 7 p.m.
Thank you, Mr. Harkin. Madam Clerk. For which? The public hearing.
Notices of tonight's public hearings were published in the Journal News. I have proof of publication which is available for inspection in my office. Each speaker shall be limited to 3 minutes. I'll call the names of the speakers and ask that you please come down the aisle to my left behind the black ropes. The first public hearing is from the Committees on Government Operations and Budget and Appropriations on the proposed modification to the Peekskill Sanitary Sewer District by the addition of one parcel of property located in the town of Cortland. Mr. Chairman, I have no cards.
Thank you, Madam Clerk. Mr. Harkin.
I move to close this public hearing.
Thank you, Mr. Harkin. Madam Clerk.
The second public hearing is from the Committee on Legislation on a local law amending the laws of Westchester County in relation to enforcement of the Westchester County Fair Housing Law. I have one card, Andrea Klausner.
Good evening. My name is Andrea Klausner, and I am the Deputy Director for Westchester Residential Opportunities, also known as WRO. Here with me tonight is Marlene Zarfis, WRO's Fair Housing Director. As a non-for-profit housing organization that investigates complaints of housing discrimination in Westchester County, we are thankful for this and other opportunities to offer our input on the county's fair housing protections. We were gratified to be invited to speak at meetings of the Legislative Committee when this issue was being addressed and to submit subsequent written testimony regarding the efficacy of the county's fair housing law. I have an additional copy of that written testimony that I would like to offer into the record. We are similarly grateful for this opportunity to publicly support this important and necessary amendment to the Westchester County Fair Housing Law. However, now that we have had an opportunity to read the most recent text of the proposed local law, we believe that there are 3 areas where the language does not go far enough to ensure the substantial equivalence required by HUD and should ideally be made a part of this law. First, we believe that Section 1F3 should include a requirement that the Fair Housing Board provide a detailed investigative report when it makes a determination of probable cause or no probable cause at the conclusion of the investigative period. What is to be included in this report is specifically spelled out in the federal regulations and implemented by HUD after its investigation and determination process under 24 CFR Section 103.230. This is necessary to create a formal record that allows either party to appeal the determination. We have a copy of this federal regulation to offer into the record. Second, we believe that Section 1F6 should be amended by adding an additional paragraph G that would clearly grant the Fair Housing Board the ability to award attorney's fees during the administrative process, including during conciliation or an administrative hearing. The award of attorney's fees in a civil action is spelled out in Section 2 of this proposed law, but the proposed law is conspicuously silent on this issue in the administrative process. The award of attorney's fees is provided under federal regulations in the administrative process under 24 CFR Section 103.315, a copy of which we also offer into the record. Third, can I go on?
No, ma'am. What you can do is you certainly can give us a hard copy of your comments for the record, but if you could just do your wrapping paragraph, that would be good.
Okay. I will try to wrap up very quickly. The last section, in Section 2A2, we believe the language is a little ambiguous. We're not sure that it mandates that the county attorney bring a civil action every time the Fair Housing Board authorizes it. And we have language in our written testimony that explains that. But we want to thank you for giving us this opportunity and for your support of fair housing rights for all residents of Westchester County.
Mr. Chairman, no other cards?
Thank you, Madam Clerk. Mr. Harcum.
Thank you, Mr. Chair. At this time, I would move that this public hearing be closed.
Thank you, Mr. Harcum. Madam Clerk, let's do public comment.
Again, each speaker shall be limited to 3 minutes. I'll call the names of the speakers and ask that you please come down the aisle to my left behind the black ropes. Ed Riley, Murray Bowden, Regina Riley. And the first speaker is Ed Riley.
My name is Ed Riley. I'm from Croton. You know, this county legislature never stops giving in terms of information which some people would find outrageous, but it's really run-of-the-mill here. If you look on your website on the Charter Revision Committee and how Mr. Wishney ever got the head of the Charter Revision Committee, I will never know. He didn't even know we were in a financial crisis in 2002 to 2003. But they had as a guest Andrew Spano. And you may wonder why this county has a housing settlement with the federal government where the county executive lied on the paperwork. Now, in any other place, he should go to jail and he should pay the money, not us. But it says here, this is Andrew Spano's philosophy in the Charter Revision Commission. He wanted to distribute county resources to local government. Basically, I had a plan. This is a quote. I had a plan. I basically ignored the charter. Why is he appearing before the Charter Revision Committee? Basically, I ignored the charter, and somehow I would get the resources to these different parts of the county, and hopefully I would get them there legally. If not legally, I would get them there illegally. This is the county executive of Westchester County. No wonder there's a housing settlement with the federal government costing us $92 million, because the federal part of that is our money too. Think about that. He sent his disciple, Larry Schwartz, to Albany, and he worked for Patterson, now works for Cuomo, spreading his gospel of good news. Now, I'm sure by now, the three conspirators on the Community Services Committee, Williams, Myers, my own representative, Mr. Harcum, and the fifth have consulted with Planned Parenthood and told Planned Parenthood it would be embarrassing if there was an injury or lawsuit concerning RU46. By the way, one of those drugs specifically says by the manufacturer, do not use this on pregnant women. Specifically says. I'm sure they've consulted and said it would be a public relations catastrophe if there was a major lawsuit concerning RU46 and Planned Parenthood. And I'm sure they consulted with Planned Parenthood, told them that, you know, it's embarrassing to look in the New York Times and find out that the plant that manufactures RU46 has been guilty of so many manufacturing errors, manufacturing corruption, and manufacturing injuries of other products they produce to the children of China. That they should have talked to that. They've talked to Lisa Windjam about 100 times, and Rena Schifrin about 100 times in the last year. They probably consulted with them about that. It wouldn't look good to have Planned Parenthood come out in the wrong end of the stick. And it wouldn't look good to have a person at Planned Parenthood be willing to cooperate in an advanced abortion for sex selection. And you would not know about sex selection because the press has cooperated with Planned Parenthood. You know this human rights activist, Chen Xiaocheng.
Mr. Raleigh.
Just came to the United States. His principal activity in human rights was to prevent forced abortions and the torturing of the family of women who refused to have abortions under the Chinese one-child policy. And you notice that the Democratic caucus, the party of abortion, has said nothing about this.
Murray Bowden.
You kind of, well, let me back up a minute. My son's getting married for the second time on Father's Day, and I'm rehearsing being calm and polite. So this will be a little slow. Your fire officers here tonight made me change my presentation. I was impressed by their desire to do the right thing and your support of them. I sent an email that I hope all of you have, and I'd like to read part of it right now. This is from Police Chief Magazine, and the link is on the email that I had sent to you all. And I'm going to read item 4. And it says, ensure officers wear mandated high-visibility safety apparel. That's the reflective vest I have on. Law enforcement officers directing traffic, investigating crashes, or handling lane closures, obstructed roadways, and disasters on all public roads now are mandated to wear high-visibility safety apparel meeting certain standards. The mandate to don high-visibility safety apparel increases exponentially the odds that officers will be seen by motorists. Over 17 consecutive years, 1993 to 2009, an average of 1 officer per month was accidentally struck and killed by a vehicle. For each one involved in a traffic stop, almost twice as many were directing traffic, assisting motorists, and so forth. The most people who are concerned about this issue are the families of police officers. I met with your senior police officers in Hartsdale. Most Westchester police officers, as New York State troopers, do not wear the mandated vests. It's a cultural issue. We're not going to obey the law because we don't feel like it. I'm notifying you that it is your responsibility as a legislature to enforce the law as written. And now that I'm on the record, and you are notified, I guess lawyers call it prior notification, I've created a liability, a possible liability that if an officer is killed without a vest on, this legislature has been negligent in their duties, and a good hotshot lawyer is going to sue for a lot of money. It seems that the only way to get change is to create a liability where it's going to cost you money. I was coming from a meeting at the Westchester Transportation Board at the airport, and we were reviewing the traffic lines there. The people who run that airport do a very good job of it. They've been very helpful to me. I'm meeting with their staff next Tuesday at 10:30 in the morning to review the lines, and I think you're going to have an airport with the best marked roadways of any in the United States. So on that point, you got a good team there.
Regina Riley.
I'm Gina Riley. I'm a constituent of Catherine Borgia, the 9th Legislative District. And just to answer to what that gentleman had just said, the only way that the Board of Legislators will actually do something regarding that thing is if each of them were personally liable, not with our tax money, which they seem to be very free with. In August, we'll be celebrating our 11th annual Women's Equality Day Reformed Day. The Woman of the Year award that for the last 10 years has been given to the Westchester pro-life woman who has contributed to the local community through her professional and voluntary vocations. This Mott Stanton Anthony Award is named for 3 of our foremothers in the women's suffrage movement. Their anti-slavery beliefs, women's suffrage beliefs, were logically completed in their pro-life beliefs. They understood that neither a person's skin color nor a person's age in the womb or outside of it should determine that human beings' inalienable rights. Another foremother, Alice Paul, the founder of the League of Women Voters and author of the first Equal Rights Amendment in 1922, expressed her dismay when the Equal Rights Amendment of the 1970s was broadening abortion to a right. She said, "Abortion is the greatest exploitation of women." There is a bill in New York State's Senate to outlaw gender discrimination, abortions. The abortion industry, including Planned Parenthood, is against this bill, which exploits women in the womb and their mothers as well. To celebrate all women and the suffrage adult women enjoy, we are going to, we commemorate the 26th August 1920 passage of the 19th Amendment. And on a Friday, early in August, we will invite all of the Board of Legislators to celebrate the passage of the 19th Amendment and all the contributions of women leading up to that passage and stemming from it. So I hope you'll take that into account and be there with us. We appreciate it.
Mr. Chairman, I have no other cards.
Thank you, Madam Clerk. Let's go back to the regular order of business under unfinished business.
Unfinished business, item number 5269 was held over from the May 21st, 2012 regular board meeting agenda. Appears here as an item of unfinished business for committee referral only. It's the appointment of Kimberly Morella as a member of the Westchester County Fair Housing Board for a term to expire December 31st, 2012.
Madam Clerk, a long roll call vote.
This is to refer the item to the Committee on Appointments. Mr. Harcum.
Yes.
Mr. Mazzano.
Yes.
Ms. Borgia.
Yes.
Mr. Burrows.
Yes.
Mr. Gelfarb. Mr. Kaplowitz.
Aye.
Ms. Marcotte. Ms. Myers.
Yes.
Ms. Perez.
Yes.
Mr. Ryan.
Yes.
Ms. Shimsky.
Aye.
Mr. Smith.
Yes.
Ms. Spreckman. Mr. Testa.
Yes.
Ms. Williams.
Yes.
Mr. Williams.
Yes.
Mr. Chairman.
Yes.
17-0, the item is referred to the Committee on Appointments. The remaining items under unfinished business were all held over from the May 21st, 2012 regular board meeting agenda and appear here as items of unfinished business for action. Item 5189 from the Committee on Appointments is a resolution granting a waiver of the Westchester County Code of Ethics to permit former county employee Richard Stiller to accept employment with the White Plains Bus Company.
Ms. Shimsky.
Thank you, Mr. Chairman. The Appointments Committee examined this issue, determined there's really a lack of substantial overlap between what Beeline Buses does, which of course was Mr. Stiller's function with this county for many years, and what White Plains Bus Company does. I understand there's no current contractual relationship between the two. Under these circumstances, the committee felt it appropriate to grant the waiver.
Thank you, Ms. Shimsky. Members on this item? Unless there's objection, members, we'll take the prior long roll call vote for the approval of the item. So ordered.
Approved 17-0. Item 5279 from the Committees on Community Services and Government Operations. A resolution directing the county executive to reserve a portion of the North 60 parcel for the development of a residential and educational facility for developmentally disabled children.
Mr. Hawk.
Recommit, Mr. Chair.
The item is recommitted.
Item 5146 from the Committee on Budget and Appropriations is an act amending Act Number 25, 2011, increasing the not-to-exceed amount under an agreement with Wilson, Elser, Moskowitz, Edelman, and Dickler and the County of Westchester for legal representation in the lawsuit entitled CSEA et al. Versus County of Westchester et al.
Mr. Hawker.
Recommit, please, Mr. Chair.
The item is recommitted. Next item.
Item 5305 from the Committee on Rules is a resolution authorizing the chairman of the board to seek declaratory judgment regarding the laws of Westchester County, Chapter 188, modifications to franchise agreements bus routes.
Mr. Harkin.
Thank you, Mr. Chair. First, a general comment, if I may. There may be a few resolutions to follow this evening. I think it's clear to everybody that there are certain issues where we've hit a road jam, a log jam. I think both caucuses have admitted it. I think the administration has admitted it on certain items, and we need clarity and we need closure. In certain instances, leadership has tried to negotiate, and we've been told, take us to court. I myself have heard that several times, and it's unfortunate. But I put these resolutions forth from the Rules Committee not in the spirit, quite honestly, of a confrontational exercise. We as a government and as a people just need clarity and closure. Whatever the results of this third party, so be it. We need to be able to move on for the people of Westchester. We need to be able to conduct business. So there may be a few more of these later this evening with that as the background. This having to deal with franchise agreements, where the charter clearly says that changes to franchise agreements must come through the Board of Legislators. And in at least one specific case, that was not done. And when it was appealed to the state actually said that a court would need to decide and to arbitrate the final disposition of the matter. So we're not the only ones saying that court-ordered clarity needs to come to this. That's the state regulatory authority saying that. So with that said, the other thing that we did want to say is that originally there was kind of an omnibus resolution that came before this board, and many of our colleagues on both sides of the aisle said that rather than have, this kind of amorphous omnibus resolution, that if we were going to go down this path, that members wanted one vote on each issue. And that's what the Rules Committee has done. A number of them were drafted. We've moved a few of them forward that we felt dealt with process issues, that were not individual legislator issues or pet projects or pitting one district against another, but were actually process issues that hopefully could bring some clarity to the process and the communication between the two branches so that we can move forward for the people of Westchester. So moved, Mr. Chair.
Thank you, Mr. Hawker. Mr. Burrows.
Thank you, Mr. Chairman. Point of information, and while I would like to stand and rise and join Mr. Harcum with the clarity and basically, I believe and agree with him that it's unfortunate that I believe some of these issues that are taking place between members of the board and the respective aisles, and while I do believe that there's process issues here, I think that this resolution, as well as the 5 other resolutions, are being brought incorrectly. And in reading our charter and the powers and the duties in Section 209 that deals with that, I'd like to ask the county attorney, who is our attorney, who's the attorney for our government here, regarding number 7 as well as the other resolutions, and particularly asking whether, in his opinion, this should be brought on by resolutions and or another method, in particular whether it's an act or a local law. I don't believe, and members of my caucus also don't believe, that this is being brought properly. And I'd rather rise right now on item number 7, because the next 4 items, although I believe one is being recommitted also, are all issues that I believe are being brought in properly. So with that having been said, I'd ask that Mr. Meehan give an opinion on whether in fact the board is proceeding, in your opinion again, accurately by resolution. Should it be done by another method? Is in fact this process correct?
Well, first, Mr. Burrows, I'm running the meeting, so we'll determine that in a second from that particular point of view. That's your comment at this point in time, Mr. Burrows? Is that your request?
Yes, Your
That would be a motion that you would like to make?
Yes.
And that would be a second on that particular motion at this particular time.
And again, it's point of information is done all the time, so I don't know why we'd be even talking about it.
I'm actually just going in process order, Mr. Burrows. It's a point of information that you're requesting. Mr. Meehan, Mr. Burrows asked the question.
Yes, Mr. Chairman, the action by a board for the transaction of the business of the county, which should include the authorization to commence a lawsuit, must be by act under Section 209.91, Subdivision 4. So the answer is, it must be done by act.
Mr. Meehan, would you cite the section in the charter that also identifies that the Board of Legislators has the ability to hire outside counsel from time to time as well? Is that part of the charter that you would like to recite at this point?
That is a separate question. The question of whether or not the board can hire outside counsel is...
for transaction of its business? Is the business of the county that charter is referring to?
Well, certainly the hiring of outside counsel would be done by act as well, so that the same rule would apply, but there are certain conditions before the board would be empowered to do that.
Thank you for your opinion, Mr. Meehan. Any other comments? Mr. Kaplowitz.
Thank you, Mr. Chairman. My comments will be procedurally, if I might, sir, in regard to this and subsequent items within the spirit of, though I will stand substantively as appropriate on each of the items that are before us. I stand kind of in awe of what's happening. Awe because I see us trampling some procedure, in awe because we're very lightly trying to engage, or some are trying to engage in legislative steps that are quite extraordinary. In the 14-plus years I've been on the board, I don't recall ever once being asked to sue another branch of government. I recognize that a colleague and some colleagues across the aisle had done so in the past and utilized their power, as individually we all do have. But I certainly know that in the years I've been on the board, that a legislator who also happens to be an officer of the board, and actually 2 officers of the board elected by the board, never engaged in such action. Now, it's not to say that it's not possible, It's not to say that it's not necessary at times, but I stand, and my initial comments are that it really shouldn't be done lightly, and it should be done with a standard and a procedure that in all cases I don't think really have quite been both enunciated and then when one thinks them through have been followed. So it's a sad day that we're here, where we have basically declared in the global picture that negotiation and the art of legislation and compromise has failed, and in fact it's necessary to throw the red towel in football parlance and go to the referees or the instant replay, in this case to go to the third branch of government. But I, sir, hold out that certainly that would be appropriate necessary times, and as we all know, in our federal system, there are times where you do need to go to the third branch of government, the judicial branch. Congress has done it, and the state has done it in various times, and so it's certainly possible that the county would. But, sir, I would put on the record, perhaps, and I've given a lot of thought, as we all have, to this, some criteria that would be, I think, a test, a checklist test, if you would, sir, that would have to be both enunciated and then followed to see whether such extraordinary steps are necessary. And I would put forward the following: whether our legislators choose to engage in that methodology or any others, that's of course individual legislative prerogative. But I'm just, for the record, sir, putting forward these, and I'm going to kind of run all through this litmus test, again, given the extraordinary nature of what we're being asked to do. And so the standard, or the checklist, if you will, sir, in the four orders that I have it, one is that there is a specific remedy that's being sought, or an ascertainable issue that is being asked to be resolved, that is at a stalemate at the county level, at the legislative level, and the interplay between the legislative and the executive. Great philosophical, great public policy, that still remains in the legislative and executive discussions and domain. So is there a specific remedy that's being sought? Two, is it cost-effective litigation? That is, that given the cost of bringing this litigation, the benefits that we derive and the understanding, do they outweigh the cost? Certainly we have chafed at this board in the past where we've been asked to engage experts, engage counsel, and the costs have been in the millions. The case that comes to mind is the lawsuit proposed against KPMG, the auditors and accountants for the Westchester County Healthcare Corporation. And this board was asked for a not-to-succeed amount that grew as soon as it was on paper, and it quickly became clear that the cost of the litigation to potentially bring back some dollars was just not worth it, and all litigants have to consider that. What's the cost and what's the potential benefit? Third, it has to pursue appropriate policies. That is, if we win on academics but we lose on substance, what are we doing, and why, in fact, we do it? And each legislator, and it'll come in specifically my regard to the first item, are we pursuing appropriate policies? Do we win anything from a public policy standpoint, even pursuing this? And fourth, and maybe most important in my mind, sir, have we exhausted all reasonable legislative options, specifically that of the lost art, unfortunately, of what we used to call negotiation. It's called compromise. It's called appropriate discussion. There is a very healthy tension that's set up on purpose between the branches of government. One is not preeminent over the other. And unless you have exhausted all those reasonable legislative options, I just don't think that it would be appropriate to then go to the judicial branch. So, sir, using that standard to this first one, item 7, I'm not convinced at this time that on the test of either specific remedy, because I'm really not sure under 7 what we're asking a declaratory judgment for. Are we trying to get the old line back? Are we trying to obviate the state approval of the new modified line? Are we wind up hurting everybody else along the line, but for the people, the 30-some-odd riders at the end of the line, if in fact we're successful and we can't modify the bus line, so therefore many other riders are thrown out? Are we pursuing an appropriate policy when it's, from a budgetary standpoint, clear that while 30-some-odd people are quote-unquote hurt, and I I respect that, and I think we all take that very, very seriously. Don't do it lightly, but in the same breath recognize that it's a savings of $250,000 or more to where these 30-some-odd individuals are hurt, and recognizing that at $8,333 approximately per year, or $30-some-odd, $32 per day on a business basis, we could hire cabs, and the administration is looking to do that. And through the process that the administration followed, all the rest of the people along that line have lines that are modified. And then you recognize, certainly as a legislator from the north, I've had it maybe more than most, but through the years, lines have been constantly changed and cut, and I've not been happy about it, and I've always tried to argue that, in fact, they should be kept. Just this past week, I was in Yorktown, and a senior citizen said to me, "What about the bus line we lost? Can we get that bus line back?" And the truth was, sometimes in life, the costs just are not reasonable, and that the benefit is outweighed. And it's hard. If I was the legislator for that area, I'd be doing precisely what's being done here. But we, as fiduciaries for the overall health of the county, have to look to the overall health of the county. So, sir, on all bases, I'm gonna, unless I hear otherwise, and I've been listening very carefully to what everyone says. I mean, I don't commit to this lightly nor with mind made up, but I do and will be applying against some standard that I've enunciated. I'm even open to other people's standards. But unless it meets the four-pronged test, I just am not prepared to declare defeat and the end of discussion. And there are times where you sometimes have to take a step back and have to try to accept some small defeats, but that in the end, we do the best we can moving forward. And this, I think, is one, sir, where I think the overall unfortunate decision for the county is best to move forward, and I just don't think the courts can, employing that with all its costs, play a role in number 7 in the resolution of this 188 franchise agreement. So thank you, sir, for the chance to lay out and then apply the standard.
Thank you, Mr. Kaplowitz. Other members? Mr. Williams.
Thank you, Mr. Chairman. I just want to, for the record, add my comments to these resolutions on which we will be voting on tonight. I think we've heard the word compromise, and I agree that compromise is a means by which reasonable people try to resolve their differences. And I think the dictionary definition says a settlement of differences in which each side makes concessions. It's not a one-sided issue. Now, I think what's been described is not compromise. It's really surrender by a legislative branch of its prerogatives to enact legislation and see that legislation enforced. And I don't believe that that is a workable solution, or ought not be a workable solution for any legislative branch, for it goes to the core of what we were elected to do, which are to pass laws. And in terms of the processes or procedures, whether they're correct or not, I think the reason why we are here is because there has been advice given that much of our legislation can be ignored. Can be ignored. And that is the reason why we're at the process. We don't have an uninterested arbiter who would advise both sides, taking into account the balance of interest in an executive and legislative branch. If we did, perhaps we would not have been, or we would not be at loggerheads on many of these issues. But if you don't have reasonable people being able to reasonably discuss an issue and reasonably come to reaching differences, but has a one-sided approach that says, I'm going to ignore legislation that you passed. The legislative branch has no authority to enact legislation that is not acceptable to the executive branch, and that's what we are faced with. Then I believe that the courts in our system was set up for that precise purpose, to be able to be the arbiter, the person, the branch of government that would and clearly have the ability to say whether or not the law should be followed, or should not be followed. I think when you go to a court process, perhaps it's not something that we take easily, but it does settle differences. It does settle, I think, from both sides, an understanding that laws are made to be followed. If it does not, then we end up continuously with these differences day after day. And I think that we've got to come to a point of closure. Closure will not be sitting on one side and just remonstrating, let's compromise, let's compromise, let's compromise. And when there are no concessions on the other side. I don't know of anyone who actually can truthfully say that there has been no attempts to reach compromise. I mean, they can say it, but whether or not that's factual is another issue. Because I think that there has been attempts to compromise. Just does not work. And I think that when it does not work, there are either two things you do, and perhaps what's being advocated is that we surrender our legislative prerogatives and just say, okay, we pass laws here, whatever happens to them, whatever happens, happens. And that is untenable, I can tell you as one legislator. I don't believe in, and I don't think many of us look for the lawsuits. Many of us do not look to get into controversies. But we certainly don't believe that being reasonable individuals who try to reach a solution and being placed in a position where we are constantly dismissed, that is not a position that many of us who are sitting here would take. I think you want to work through items, but I think working through take both sides. And if you don't have reasonable minds who will sit and say, why don't both sides try to work this out? Then I think that it's the comments that, well, the legislature never tries to compromise. I don't think that it is certainly not factual based on what I know as a legislator here, because I think we've had many, many attempts to reach compromise, and I don't think surrender is compromise. Thank you.
Thanks, Mr. Williams. Other members? Mr. Ryan.
Thank you, Mr. Chairman. Seeing these resolutions on the agenda tonight, I think my original plan was to address each one as a member through my vote. And I've already decided how I'm voting on these. And I didn't really want to get up and speak on it. And I'm not going to speak very long about it. But one of the things I'm not going to do is go through an analysis, because Bernice would be upset with me. I go through an analysis of how the two sides of the aisle feel about things that are properly within the domain of the legislature to address and act on. Because I don't know whether or not there are some common denominators that are so obvious, but I will cite one item, and I'm going to make reference to a discussion that I had with a good colleague of mine, Jim Mazzano, where as two legislators, we came out of a session with the administration thinking the same way about the administration's view as the executive branch and our view as legislators with respect to the budget process. And I'm carving this item out. It's item 11, seeing as how the first item that was introduced has kind of triggered a discussion that in some respects is blanketing all of them. So let me just kind of continue that pattern and just talk briefly about item 11. I think the thing that, if I don't want to put words in Jim's mouth, but the thing that kind of bothered us after the meeting was that we had a very clear understanding as to what we were able to do, what we were responsible to do when it came to the proposed county budget for the ensuing fiscal year after it was presented to us. And we didn't do these things because habitually we had done stuff, or somebody came up with a good idea and the majority bought it, and so we decided that we would go down one road in a certain given year, and if we came up with something, you know, something unique the following year, we might try another approach. It's much more formal than that. In fact, when it comes to item 11, and specifically additions to the county's capital budget, and here we're talking about the board's work that could result in the revision, the alteration, increase or decrease in the proposed county budget. And once again, for the purposes of my remarks, I'm talking about the operating budget, the capital budget, the budget message, and let me put into this recipe, you know, things like just inclusion of the report of the capital budget committee, because that's called for by our charter. There are very specific things that we are able to do. But this isn't things that the Democrats are able to do, or just the Republicans are able to do. These are things that the legislature in its entirety is able to do if it so chooses to do. Obviously, we've arrived at a point with respect to additions to the capital budget. We've arrived at a point where our opinion is different from the county executives, from the executive branch. And I don't think it's a question, not enough time put into, you know, negotiating and trying to talk it through again. I mean, there are very real things going on here. Items not included in the published budget. One branch seeing the capital budget for a given year one way, and ours seeing it in a different way with many more items included in it. We have a public that views our work. We have a financial community that views our work. They look at our capital budget, and they see after the budget work has been done and the vote has been taken, they see published documents that are different. The idea of the executive branch is clearly different than the legislative branch. And then, where the rubber meets the road, we're seeing projects not recognized by the executive branch or the departments that are supposed to be working on them. And a clock ticking, where no work is being accomplished because the one branch has said, well, those projects don't exist. Those items in the capital budget don't exist. To get back to my point about we just don't kind of do things, you know, just by habit or at the spur of the moment what we feel like doing. There are very specific rules. And I know everybody in this chamber has read section 167, 101. Do you know exactly what the charter says with respect to our rights and responsibilities, our power and authority with respect to additions to the capital budget? There is no gray area here. If we follow the procedures that are in section 167, we are able to make additions to the capital budget. Now, this is all playing out in the context of another conversation. It's a conversation that has to do with very specific deadline in May that you know, departments and agencies and boards have to comply. Well, and we hear, well, boards, well, County Board of Legislators, that's a board. Listen, folks. The charter is a very careful document, and as kind of like an owner's manual for how this whole thing is supposed to operate. When there is a reference to the County Board of Legislators, believe me, it's going to say County Board of Legislators, it's going to say County Board, it's going to say Board of Supervisors. The only debate really that could come up is perhaps by someone that might be new to the board, and they might ask, well, why the reference to the Board of Supervisors? And the veterans in the room will say, well, actually, the law has covered that. Any reference that still exists in the law that has to do with, that states the Board of Supervisors it is to be interpreted to mean the County Board of Legislators. So anyway, and we've all seen that little bit of education go on in here. But let me tell you something. The charter does not go page by page and just kind of refer to the Board of Legislators as boards. If it's meant to be applicable to the Board of Legislators, it'll say County Board of Legislators. We know that. So anyway, let's kind of set that aside. So here we have a question tonight. Is a resolution the proper thing? Is an act the proper thing? A local law the proper thing? The point is, we've been driven to a point of frustration as a legislature because we have followed the rules. We have followed the law. We have done what we are legally able to do. We comply with the dates, the publication requirements. It doesn't say add days in 167-101, but we know what the memorandum of proposed additions coming out of the Budget Committee on December 1st is. It's ads day. That's when we put in the ads to the operating budget, the ads to the capital budget. And that's what historically everybody in the Westchester world has seen from this legislature over the years. And we have done that, and the only time we've run into a problem is within, I guess, the last 2 years, where we have this different view. To get back to my point about the charter and May 1st, yes, we acknowledge the county executive has a very important job to do. He has to compile a lot of information from a lot of different cost centers. He has to work on this stuff with his team and eventually come up with a proposed budget that deals with operating and capital. And he has to give it to us. And it's a very important process. It's a complex, detailed process. It takes time. And the budget does the charter does a very good job in specifying step by step what has to happen and who has to come in and weigh in on things. It does an excellent job. And we have discussed around the committee table our recognition of the very good job that the charter does to specify what executive departments of this county and the agencies and any of the cost centers that answer to the county executive, what they have to do and by what deadline they have to do it by, and the process they're involved with. We recognize that. But the administration is wrong when they attempt to put into that same bucket the other branch of government that is not under the thumb of the executive, that does not participate in that process, has never been meant to participate in that process. And simply because the charter mentions that the chairman of the board and the chairman of the budget committee have a seat on the capital projects committee, that doesn't mean that all of a sudden the power and authority of the Board of Legislators all of a sudden goes out the window. We have no ability during the time that we are working on the budget to do the things that we know we're able to do: revise, alter, increase, and decrease the proposed budget, as long as we follow the procedures. So what are we doing here? I mean, you know, one branch needs to respect the power and authority of the other branch. The executive needs to do that with us. We need to do that with him. We don't have the same powers, we have different powers. They're all important and they all have to work together. And in this particular case, there's a rule book that he has to follow. If we, by charter, decide to take some actions where we amend what he presents to us, that's not the last word. He has the ability to take back from us what we act on. He can veto. But then again, that's not the last word either. The charter says, well, it comes back here. And if we can muster enough votes to override the veto, then we arrive at the end of the year with a legitimate item to be published in
the proposed budget, whether it's operating or capital. The rules are very specific. And let me let you in on something. I don't think anybody's going to walk in this chamber and acknowledge it from the 9th floor, but even people up on the 9th floor understand that when they hear the entire process the way it's supposed to operate, the Board of Legislators complying with the charter, following the charter rules, and then knowing that you get into the ensuing fiscal year, and at some point those items are going to be brought up that have been added to the capital budget, we have always acknowledged that now the same process applies. The planning board, the capital projects review. We have never said this is a shortcut, but we have said that our important work is not part of just another department of the county executive to comply with his schedule, to give him his projects, to let him mull them over and decide, well, I'm not going to include any of these things. It's not how it works. We are a co-equal, independent branch of government. There is a time that the charter says that we act on what has been delivered to us. And it is expressly stated what our rights and authorities are with respect to alteration, increases, decreases, changes to what is given to us in the proposed budget. Once again, folks, it's not gray. It's black and white. It's in those pages. I said everybody's read it. I hope you've all read it because it's come up an awful lot over the last 2 years. This is important stuff. And so why are we frustrated? We're trying to figure out, well, maybe a more streamlined way to get to a point where we can have the judicial branch weigh in on this is just to kind of delegate that response. That's really what this is. It's a resolution that's delegating what ordinarily we would do in another way, in another form. We're not here to, I guess we didn't come in here today to discuss whether or not it's a resolution or it should be a local law, a resolution should be that. The point is, we are driven to have to seek the judicial branch's determination as to what we've done. Because we can't seem to, in this House, at 148 Martine, we can't seem to come to an agreement as to whether or not the executive has certain rights and responsibilities, and the board has certain rights and responsibilities with respect to the budgetary process and the ultimate approval of the final budget that happens to contain the capital budget, which what is item 11 is all about. So anyway, I tell you, it may be similar, but for my purposes tonight, as you've seen, I focused just on this one. It bothers me. It bothers me that any legislator, and maybe none do, but any legislator would think that the executive branch has the right to take that power and authority from us. Because every single one of us in this room knows that the executive branch does not. It has the right to do the things that the charter says that it can do in response to our actions. But it does not have the right to take from us the authority that the charter grants to us. For that reason, when this item comes up in particular tonight, I'll be voting for it.
Thank you, Mr. Ryan. Other members? Mr. Maison.
Thank you, Mr. Chair.
Yes, sir.
I think this is an unfortunate time in our county's history, and I'm just going to speak for myself. I'm not speaking on behalf of my caucus. But I think this is quite an unfortunate time in our county's history, and I'd like to put a few things on the record to explain why I think that. Number one, just for some of the procedural issues, I do think this board needs to take very seriously the opinion of the county attorney that these actions were about to be done, are about to take place, these votes, should have been done by act, not resolution. I think that's important. I don't think it's been discussed enough in detail. The charter tells us the county attorney is the one who's supposed to give us advice on these very issues. And we're rejecting that advice, and I haven't seen any legal paper in front of me to say that the county attorney's wrong. Apparently taking an action right now, there's no brief here. I see no legal brief here. I have nothing here to tell me the county attorney's opinion on the record in this chamber at a formal meeting is incorrect. So at this point, If for nothing else, I will vote no, because no one's given me a rationale, a legal rationale, that doing it by resolution is the proper way. I have the county attorney, my attorney, under the charter, telling me that this should be done by act. For that reason alone, I'll be voting no. But I have more important, or not more important, but other important issues I'd like to talk about. And lastly, on the procedural thing, I do want to point out, I don't, for this resolution in particular, although I think it's true on at least 2 others, I don't think the resolve clause is clear enough to indicate what these actions are seeking in their declaratory judgment. This one says, seek declaratory judgment regarding LYC Chapter 188 modifications to franchise agreements - bus routes. Okay? What does that mean? That doesn't mean anything. That is not specific at all. I have no idea what you want a court to law to say based on that resolve clause. No idea. No one could. If we gave this resolve clause to 500 people in the street, they would read it, and not one person could say, I know what you're suing about. I know the relief you're seeking on declaratory judgment. Nobody could. You needed to be way more specific on these resolve clauses if you wanted legislators to vote to support you to bring legal actions asking a court to do something, seeking relief in the form of declaratory judgment from a judge. We need to know what you want. This doesn't say it. Doesn't say it at all. Now, the reason I said this is an unfortunate time in our county's history is what really bothers me. I dealt with the 2 procedural things, not being specific, and the issue of whether it should be an act or resolution. Those are important issues and need to be discussed more as well. But where I'm going to come in here, and I appreciate the comments of Legislator Ryan. We've been here the same amount of time. We came here the same day. And I understand his points of view. But I'm going to say this about everyone. Me, our side of the aisle, the Democratic side of the aisle, the county executive. This is a failure of leadership on everybody's part. The fact that we're heading to court to have judges make all the decisions that we were all elected to come here to make. Simple as that. All of you, every one of us, all 17 of us in our districts got elected to come here to work together, both as legislators and with the executive branch, in a collegial, bipartisan, professional, and thoughtful way, make hard decisions and run this county government. As Bill Ryan said, we have different duties under the charter that are spelled out. But we had a job to do, and if these there's four more litigations here tonight that we're going to vote on. There's 2 already pending. That would be 6 litigations pending between the branches of government, and there's 9 more in the Rules Committee. That's a failure in leadership by everyone that we're at this point. And it's so troubling to me. There was a couple discussion by some people, Legislator Williams, Legislator Ryan, Racing, Legislator Kaplan, whether an effort at compromise was sought. And I would submit to you, as one of the leaders of this board who has been involved in compromise conversations, while there were conversations, they weren't good enough by everyone. They weren't productive enough. They failed, and they shouldn't have failed. And I'm not going to start blaming anyone right now, because we all failed here. If you approve these items, these resolutions tonight, and more litigation is pending in the courts, possibly 6 different litigations in the courts to solve the decisions we were all sent here to make. Now, I would submit to you that, well, first of all, let me say this. I've been here 15 years, and I would go back 2 years before I got here, so 17 years. There's been 2 litigations in 17 years between the branches of government until this last year or so. 17 years, 2 litigations. Those boards of legislators and those county executives figured a way through the time. And to be fair here, I brought one of the litigations. I brought the litigation because the county, there was a piece of legislation pending on our board to allow a sewer line to be moved. As Bill kept pointing out, I hope you all read the charter. If you read the charter, it makes very clear that all actions relating to the moving of county property have to be voted on by the Board of Legislators, and actually need a supermajority vote. And because the item was blocked on the board and didn't pass, the county executive, through the A&C board, gave a license to a developer to move the sewer line. And it took effect immediately, and I had no choice at that point but to bring the legal action because the county executive, in my mind, so clearly violated the law. And I'm not saying my situation is so different, so nobody needs to jump up and say, it's just like now. I'm not getting into that. Just told the reason why I brought the action because it was final and the sewer line was actually being picked up and moved, physically moved. You could argue that there was a failure of leadership when I had to sue the county executive. I'm not going to disagree on that. It was quite unfortunate that happened. But I'm going to say the following to you. As someone who's run for judge, someone who's litigated in the courts of the state for 20 years in both federal and state court, a lot of litigation experience my entire career, literally hundreds of civil actions I've been the attorney on. I have to tell you this. The courts are not the right place to make these decisions. They're not. I don't know why anyone thinks that. Most of these judges that you want to send these cases to have never seen the county charter in their life. They have zero understanding of what goes on in this building. They have zero understanding of the differences between the branches of government pursuant to the charter and the history, the procedural history that's gone on in our county. Some legislators, Bill and I and Michael, have been here a very long time, and Bernice, we've had a lot of experience with it. Other legislators are getting more and more involved with it. I would submit to you that all 17 legislators have better experience to solve these decisions than any judge I know. We have the experience. We're here. We understand how this government works. Some of us who've been here for a long time have a pretty good feel. I mean, there's no judge sitting on the Supreme Court or the county court that's going to get this case that knows more about the county charter than Bill Ryan. Not one. And yet you're going to ask these judges to make these decisions. Most of them have never seen the county charter. They never touched the county charter. They never read the county charter. And now you're asking them to speed read the county charter, immediately try to understand all that they don't know, and make a decision that's binding forever on our county government. That's why this is such an unfortunate moment, because we are sending our charter responsibility to deal with all these very difficult problems out to a judge that doesn't even know anything about this county government. That's why you're here. That's why I'm here. That's why the county executive's here. We're all here to deal with these very problems. And I really believe that, and I know some legislators feel this bus has left the station on compromise. I know some legislators think that. And I respect your views. I'm not here to chastise any of my colleagues. I understand everybody has some very strong feelings and different reasons. But I really think that these issues still need to be worked out from a compromise standpoint. I think litigation is really the wrong way to go. I don't think judges are making these decisions. I think we should be making these decisions. I think the legislators should be making these decisions. I think the county executive needs to make these decisions. I think the county executives made mistakes on these issues. I think the Board of Legislators is making mistakes on this issue. I think there's room for compromise. I'd be willing to sit in a room for 8 hours if that's what it takes to try to find compromise. But I do not want to resort to litigation to solve these very complex problems. I think it's a mistake. I've been here a long time. I'm urging my colleagues to think outside the box a little further on this and really challenge yourself. Do you think a judge is a better decision maker here than the Board of Legislators and the county executive? There are issues that are disputed between the branches that I know just me, agree with my friends on the other side of the aisle. Sprain Lake Pool is an issue, I would say to you. The county executive's wrong, okay? I think the county executive's wrong. I think that item should be moving forward this very day. And there's other things I don't agree with my friends on the other side of the aisle, but there's even areas where we have some common ground here. And I don't even think we're working together on the common ground issues. We're just heading to courts to have judges make these decisions. So I would just say to all of my friends on the other side of the aisle, I know the passions are very strong relating to these resolutions, and I know there's a lot of pressure being exerted here, but I really don't think this is the path to go right now. I really wish we could take another shot at compromising and stop putting our county into the newspapers under these litigations, putting judges on the spot that don't understand the county government, don't understand the county law. I wish we would do our jobs and settle this. And if you want to put the county executive's feet to the fire because you feel he's done things that you disagree with, some legislators here, I understand that. It's not like I don't get it. I get why some legislators are troubled by the actions of the county executive. Just because I'm a Republican doesn't mean I agree with the county executive on every issue. I agree with them on some. I agree with my friends on the other side of the aisle on others. So I wish we didn't vote yes on these resolutions. I wish we worked harder at compromise. I wish we worked harder at doing our jobs. And maybe it means we have to have additional meetings to figure out how to come to a compromise with the ninth floor. But I can't support 6 litigations at once, battling all these very important issues in the court system when it was our job to do that in the first place, and we failed. All of us have failed. Everyone in this room has failed if you bring these litigations, and the county executive has failed too. And I guess I'm repeating myself at this point, but I'm so saddened by this. I have to tell you, I'm just saddened that we've reached this day today. That there's going to be 6 litigation, and there's 9 more. There's 9 more litigations pending in the Rules Committee. It's just absurd. I mean, I think in the last 30 years, there's been 2 litigations between the county executive and the Board of Legislators. If we do the 4 today plus the 2 pending, that's 8. That's 4 times as many as all the boards and all the county executives over 30 or 40 years. That's not a great record, folks. That you have failed, this board has failed to the point that we're suing the county executive and we're having these battles with the county executives 8 times more than the last 40 years of boards of legislators and county executives. I mean, that's nothing to be proud of. And I think we need to do a better job. We need to get out of the status of failing, and we need to succeed, and we need to come to settlement and agreement, which means we have to compromise, it means the county executive has to compromise, everybody has to do their job under the charter better. And I guess I've said enough, but I hope these items don't pass, and I hope we can figure a way not to put these disputes in the court, and all of us take our jobs very seriously and try to solve these things in a legislative way, working in collaboration with the executive branch. Thank you.
Thank you, Mr. Mazzano. Other members on the items. Ms. Breckman.
I just want to sort of repeat what he says. You know as well as I do, we come from Yonkers. I'll give you a perfect example, but it's not the county. It's the city of Yonkers. I lived through it. We went through a control board. That's the same example. We needed in Yonkers people from up in the state to come down there, pay them millions and millions of dollars to do the job that the council people were elected and the mayor was elected to do. I don't want the same thing to happen in Yonkers because they are in a big financial hole, and the same thing is going to happen. They'll have to have a control board unless everybody gets together and says, we can do this job, we don't need a control board. Same sort of example. I don't want to go to court for every damn thing. Let's work together, and I'll stay also if you have to do it. Thank you.
Thank you, Ms. Breckman. Ms. Shipsky.
Thank you, Mr. Chairman. I agree with my colleagues on the other side of the aisle that I really don't want to do this, but the reason I'm going to vote for these is because I honestly feel as if there's no other choice. These are specific instances in which the county executive has looked at a duly enacted law and said, I don't have to follow it. That's not the way this country works. That's not the way this county works. It's not in the best interest of our taxpayers or our residents or anyone else. I just wanted to add for the record, in response to the county attorney's reliance on 209.99 subsection 4, that this had to be, that procedurally these resolutions should have been done by act. I would respectfully suggest that subdivision 4 is sort of a miscellaneous catch-all, and that the real section to look at is subdivision 1 and perhaps subdivision 3 as well. So it's not necessarily applicable to this situation. But in the broader scheme of things, it's important to be able to work together and to compromise. I ran on that. I do that as best I can around here. I've been able to work effectively with just about everyone in this building at one time or another on issues of common concern. I like doing it. It makes me feel better when we can do it. But when someone just puts up the brick wall, you can't compromise with yourself. That's physically impossible. And I'm sorry that this has to be done, but I see no other way at this point.
Thank you, Ms. Shimsky. Other members? All right. At this time, the only thing, and Mr. Ryan had the opportunity when we spoke, because we have individual items, but to try to net some of these items out, Ms. Mazzano has pointed out that there's failures, and I would submit that this particular Board of Legislators and the previous Board of Legislators, and for the other 300 years, has never failed at that opportunity. We work together here in this Board of Legislators, and we enact laws. And whether or not we always agree with each other on them, we have majority votes that pass those laws. And the county executive's role in the charter, because I like this particular card, with the highlight, and the very big highlight, says to see that the laws of the state pertaining to the affairs and governance of the county, the acts and resolutions of the county board, and duly enacted local laws are executed and enforced. And there, in that one sentence, is the entire reason that we have, to make a correction, 19 separate actions that are sitting in Rules Committee because of those. And whether that was Sprain Lake, the Sprain Ridge Pool, whether it's Miller House, whether it's Mountain Lakes Pool, whether it's LaPorte and Mount Vernon, whether it's child care subsidies, and all those other kind of things. It doesn't really matter, because once we pass something on the board, there is an opportunity for the county executive to disagree, and he can certainly send his disagreement, but the board at the end is the last word. That is why, as in Chapter 167 of the county charters relating to budgets, when we make a deletion, there is no recourse for the county executive. If we delete something for the budget, unless the county executive vetoes the entire budget, it's done. It's over when it gets to this floor. And one of the failures, if you will, are the reliance of outside opinions. We make laws. We are elected to make laws. We're elected. The opinions that have been rendered are from appointed individuals, and I will take them, in fairness, with positive intent. But this year alone, 2 separate judges have said those opinions were incorrect. Now, while we're still going through the process of those particular items, you all that are attorneys, and you all are great attorneys here, we have at least 5 practicing attorneys that are here. At least 5, and we have, I believe, another 2 that are not practicing attorneys that are attorneys as well. You all know the thresholds of temporary restraining orders, and the biggest one is likelihood to succeed. And we have been able to generate twice on those particular items, likelihood to succeed. And the last time we had this conversation, there was, oh, you got a friendly judge that did this. Well, this time it was a Republican judge, right? So, you know what? At the end of the day, we really just need to execute. You know, there was a reference to the number of actions. Well, I'd go back to the number of actions from vetoes if we went back to that particular point in time. If we did that, we would go back to 30 years of vetoes, and we would find out prior to this administration, the threshold mark was in 5. by County Executive O'Rourke. One of them, by the way, was for additional money for what we now call Invest in Kids, which was the Westchester County Urban Initiative, which he vetoed and the board overrode, and then the county executive, as his job, executed and moved forward with those programs. You know, I really am, I'm disappointed that people don't just see the laws, agree to disagree, and keep moving forward. And as the majority leader has stated, I was in the room when we were told by this administration, sue us. So I don't want anyone walking away from this meeting tonight or watching at home thinking that there is great pleasure in going to court and continuing to win. We don't want to do that, right? We don't like having to go to that particular point, but once this board has taken action, that should be the end. Now, as far as the budget, and the issue with judges resolving these decisions, again, that is what the judicial branch's job is. Many members have spent countless hours in meetings of committees of the whole, where we have bantered about this back and forth. And we have actually really, for me, I had some fun doing it because it was a personal project that I was working on, taking committee of the whole meetings on the capital projects and balancing them year after year. So in last session, we had the same exact conversation on capital projects. And we had pretty much the people saying exactly the same thing. Let's get to closure and let's move forward. So at this point in time, I don't believe that there is never a closed door to say, hey, you know what, we're not willing to have discussions, but we don't discuss legislation after it's enacted. After it's done, it's done. We certainly should have opportunities, and many members that are here tonight work extremely hard around the committee table in public to be able to debate the issues of the day. And they take their time out. Each and every one of you take your valuable time and sit around the committee meeting to hear those pieces of information and debate and negotiate and get to a place where we're taking a final vote on specific items and moving them forward. And we hope that the administration participates and gives us those opinions instead of waiting until after we have opportunity when we hear it through a veto. Just so everyone is aware, because we did not get this information prior to tonight's meeting, that the administration has chosen not to appeal the decision of the temporary restraining order on child care. So that is something that is on our agenda this evening as well, to continue that for that particular point. Again, enforcing the work of this board. Members go out and spend time. They spend 2.5 weeks of time during the budget hearings. They go to at least three different budget hearings. Many of you participated, even though you were not members of the board at that point in time. You were duly elected, but you still participated. You sat through hours and hours and hours of testimony from people, and then the board acted. We spent I don't know, 10, 12 hours negotiating with the administration on the budget items, that we all moved forward, and we had a great moment all together and said, this is how we're going to work together on this particular item, and enacted that. And as soon as January 1 flipped over, some of those things changed. So at this point in time, I believe that you have these opportunities in front of us, and certainly I respect every member of this board for whatever positions they take on these particular items, but at this point in time, the legislature being ignored is not an option. Utilizing opinions from non-elected officials is not the option for the members of this board. And going back and negotiating laws that we already passed is not an option. If there's a modification that needs to be made to a law, then that should be duly presented as was discussed in a different committee of the whole meeting. So at this particular point in time, for the item that's in front of us, which is 5305, we will have a long roll call vote. Madam Clerk.
Mr. Harcum.
Yes.
Mr. Mazzano. No. Ms. Borgia.
Yes.
Mr. Burrows. No. Mr. Gelfarb. No. Mr. Kaplowitz.
No.
Ms. Marcotte. Ms. Myers?
Yes.
Ms. Perez?
Aye.
Mr. Ryan? Ms. Shimsky?
Aye.
Mr. Smith?
No.
Ms. Spreckman? Mr. Testa?
No.
Ms. Williams?
Yes.
Mr. Williams?
Yes.
Mr. Chairman?
Yes.
Approved 9-8. Item 5306 from the Committee on Rules is a resolution authorizing the chairman of the board to seek declaratory judgment regarding the laws of Westchester County, Chapter 110, confirmation of appointments.
Mr. Arkham.
Thank you, Mr. Chair. Recommit, and also at this time, I would like to move for a 5-minute recess, please.
Let's go for a 10-minute bio break, if that will work better. We've been sitting for a little while. We are on recess at the call of the chair for 10 minutes. Thank you so much.
Straight to the library. Do not cast go.
No. Stop.
No.
There's immediate issues. We cannot deal with like this. Yes, first, it's overwhelming. You still might have some ability to
I just said there's these.
Why is it so cold in here? Why is it so cold here? It's freezing. It is so cold here. What am I using now?
To the food bank awards or
There's
something?
no need. We have the AC on so high.
Hold this whole afternoon.
Yeah.
You don't have it?
No, because I'm going to start sweating.
You have that? No, it's
yeah, thank you.
Tomorrow. The awards are tomorrow.
Is it gone?
No, that's. Yeah, at Abigail Kirsch.
Where is the person?
It was 10 minutes legislative time. Thank you, Mr. Burrows. Next item, Madam Clerk. We're on item number 9.
Item 5307 from the Committee on Rules is a resolution authorizing the chairman of the board to seek declaratory judgment regarding Act 2009-155, Procedures for Housing Stipulation Order.
Mr. Harcum.
Thank you, Mr. Chair. I think a lot of the macro issues have been discussed already. I would note for the record, though, that in the last comments, my name was mentioned, and I did not invoke the Rogowski rule in the sake of time. So we will just move ahead with this one. I would like to say, though, that there are no plans currently for me as chairman to be moving 18 of these through the Rules Committee. I would say, however, it might be a bit naive of us to pass acts that could be vetoed by the person that we might potentially be wanting to bring litigation against. So I think that would be a self-defeating strategy for this board to go with acts rather than resolutions. This one has to do with the housing stipulation order. If you all remember, this board spent many weeks discussing the housing settlement, actually negotiating some modifications to that with the Justice Department, and it was a close vote. It was a vote of conscience. I think everybody who was here then felt to a person that every member of this body voted honorably and to their conscience, and it was a split vote. And yet with that was a companion piece, Act 155, that passed 17-0, bipartisan, regardless of how people voted on the settlement. We were unanimous that every action in terms of implementation of the settlement needed to come before the board for approval, not for negative declaratory judgment, not the board saying, no, you can't do that, but the board needed to be involved and needed to approve. And why did we do that? Because we did not trust the administration, not this administration, the prior administration that had gotten us into the mess with the potential $500 million in fines to the taxpayers to get us out of the mess. And that's why we all wanted to be involved. And that's why we still want to be involved, because we're still facing a shotgun with $500 million in penalties coming down on us. And we shouldn't have to be saying, don't do something. We should be saying, as the partner, as a co-equal branch, this is what we should be doing. So it's unfortunate, again, but that is the declaratory judgment that we would be seeking with this matter.
Mr. Kaplowitz.
Yes, Mr. Chairman. Where do I start? So much to say, so little time. I will try to compress. First, and this hasn't come up yet, but why are we using the Rules Committee made up of 3 of the very legislators who are certainly have brought the 2 actions and might very well bring additional actions forward, when in fact the Rules Committee, in all the years that I both served on it for 2 years and obviously interacted with that Rules Committee as a legislator for 15 years now, was both in spirit and in design never the venue for purposes of discussing litigation or certainly authorizing litigation. In fact, the Legislation Committee and so many of the other committees have been utilized to reach out to more legislators to grant everyone an opportunity to understand what in fact is happening. I do not ever recall, and it's never happened as far as I know, in fact, that, we'll get to this a little bit later, that litigation is filed on a Wednesday, goes to the Rules Committee for some kind of, I guess, good legislative stamp of approval, and then shows up at the full board on a Monday evening when the 13 of us never even had a chance to see it nor discuss it, and it was simply by virtue of the fact that somebody had the decency to put it on our email chain at some point that we were in fact able to see it. It was only by, frankly, my insistence that last Monday, Legislator Shimsky was willing to even contemplate the discussion, I appreciate that, of the merit of the 5 items that were frankly mistakenly not put on a special item, otherwise these would have been rammed through, and that we even have the ability tonight to discuss, and I might say even have some of these recommitted, when if they were put on a special item, I won't say it, but I'll say it, they wouldn't have been able to have been recommitted. So that perhaps disproves the value of and the necessity of using special items, and frankly allows the sunshine of democracy and at least the veneer of good faith to weigh through. So anything that's now going through Rules Committee, I think we all need to be suspect if in fact that's the only committee, because I don't serve on rules and none of the rest of you do, except for 4 of you. And so one could say it lends a certain fruit feeling or a little bit of a banana republic to the process, and not the best fruit and the best analogy and the best process. And this is one that also kind of doesn't smell really well, because this one never even came to the full board for a sense of what's the full board's position on the substance of the nature of the appeal and that which is being appealed, source of income. I know my position, I can guess some of your positions, but none of us have ever in a committee voted, discussed, and voted what the board's position is through committee and through to the full board. So ironically, we're using resolutions, and this is the one item that we probably should resolve what our position is. County attorney was appropriately came to us. We had a committee of the whole. It was a good first discussion. And suddenly it shows up that we're saying, do not do something, Mr. County Attorney. Well, I appreciate it, except we never set policy. Committee of the whole doesn't set policy. It's the Board of Legislators. A committee of the whole is a device to inform, to educate, to, on the spur of the moment, get everybody in to discuss. But we have a whole legislative process. I had to leave that meeting at some point. Next thing I find out, there was a vote that occurred. Some of us weren't able to make it at the last minute. These things are called 24 hours in advance. And some of us can't just be here 24 hours in advance. But that's fine. You do your best to certainly be there. So the committee of the whole process, in fact, is not the best way to get to this. We don't have a Board of Legislators position on the issue of declaratory judgment of housing stipulation order. If I vote for this, I'm going to authorize the chairman to seek declaratory judgment. Unless I read about it in the paper, or if he's kind enough to send it to us in advance, I won't know what position he's going to take. So I can't authorize him because he's one person, and we haven't spoken. So I have no idea how anybody is going to support this particular item. I'm really curious to see how the vote tonight goes, and I'm more than curious that if it unfortunately passes, what the chairman's position is going to be. I can garner a guess based on comment and based on position, but we haven't had that discussion. Furthermore, in the pursuit of, or the continuation of the sadness theme, we have a duty to uphold, and I believe the county attorney in this case, in the absence of any resolution and discussion and direction, has a duty, frankly, to uphold the integrity and the process of the county, that when we've lost at some level and we were a party, he has, representing us as our attorney, the right and the necessity of appealing and then perfecting the appeal, unless and until potentially we come up with some contrary position. And as he indicated in committee, if that occurs, we go into executive session and we're going to have a long discussion. But we never went to executive session because we never came up with a position, because I don't know what the position is, and none of us do, of any of us relative to this appeal. To the final piece, I was, and 12 of us, you can't, it's interesting in a chain, you can't say any one link was the final link or was the key link in that chain, because we all were. But I was one of the 12 that did support, as the majority leader indicated, both the settlement and the appended legislation to give some process to it, because the courts were basically running roughshod over our legislative process, and we had put that in. But in voting for the 12, I can assure you we spent a lot of time on lots of components within that litigation. We spent almost no time on the promotion of source of income. It wasn't central to, but clearly was part of. And to look to the integrity of this housing settlement and to say we then all therefore stand by that piece of it, I didn't. I also didn't stand for the guilt clause, the Versailles clause, the and you caused it clause, and you should know that in fact you're the reason that there's segregation in Westchester County guilt clause that in essence was replete in a number of sections there, and a number of us pointed out that that wasn't fair and appropriate, and in fact the take it or leave it didn't give us an opportunity to fight it. We did our best. We sent legislators down, legislators Nona, legislators Williams, legislator Maizano, and came back with Justice Department additional precatory, hopefully central to language on some key components. The source of income was not one that we sent down, and we've had a healthy discussion on it. It's going to pass or it's not going to pass if it comes back to the board, and we've spoken in the past. But to take a non-central piece of this, when in fact we're complying with the full 750 units and moving forward, we're living up to this particular agreement. To now say in the absence, and county attorney, don't appeal, don't perfect, because we haven't spoken, therefore you can't do that, and you can't, on a minor portion of a less important non-centralized portion of the agreement, pursue something that you believe, in fact, and I happen to share that belief, is not central to and not the key component in this. It's an opinion, but we haven't directed otherwise. So to finish, I don't see how anybody can support 5307 to authorize the chairman of the board to seek declaratory judgment when we haven't even given any direction to the chairman as to what in fact we want to do. And when the answer was the committee of the whole spoke, then why are we here after the fact going to the Board of Legislators, if in fact the committee of the whole is determinative? And if the Board of Legislators has to speak, then where is the resolution telling us what in fact we need to do? And the committee of the whole was not determinative, it was simply a discussion. I do not, and based on what we've gone through thus far and the test that I had set out, believe in fact that litigation is effective, that that this legislation is effective, to have the county chairman step in to seek declaratory judgment when in fact we do not have a specific remedy and we do not have an issue that we're asking to be resolved because we haven't given direction, and I don't think it's appropriate at this time to give that kind of power to the county chairman. So I would hope colleagues would join us on this and give us an opportunity to once again get back to the committee structure and let the committee start grinding through their work to come up with a position, if you will. And if it's a distinction to the county attorney, so be it. Let's go into executive session and let's hammer it out. And maybe we need to seek outside counsel at that point. But until then, this is premature. We do not, in fact, know what we want the chairman to do. We haven't spoken.
Thank you, Ms. Kaplan. Other members? Mr. Williams.
Mr. Chairman, I will be brief. I just want to make 3 important points. One, the act that we are 209-155 was passed by this Board of Legislators unanimously. 2, declaratory judgment is a process by which a court declares the act valid and the law. So that's the remedy. 3, because we were never given the opportunity to sit and discuss this, because an appeal was filed, even though the time for appeal were way, a lot of time was still, we had like a 60-day period in which a notice of appeal could have been filed, not even perfecting the appeal. We weren't given the opportunity to meet as a board, both sides of the aisle, to formulate whatever position should be taken or whether or not there should be a position taken. And the 4th thing is that this act here tonight has nothing to do with source of income. So all of the statements that were made in that connection are totally irrelevant to the act that we are going to be voting on.
Other members? Mr. Mazzano.
My earlier talk about how I don't think litigation is the right recourse on these resolutions stands on this one as well. I have a specific objection I'd like to put into record on this one. Outside of my friend Legislator Williams telling me what he believes this resolution calling for a declaratory judgment, the relief you're seeking, I didn't know. I can't read this resolve clause and know what the heck you're seeking. I don't know anybody could. I don't think anybody here in this room could read this resolve clause and know. I learned more now from Lyndon Williams' brief comments than anything I read. And I don't think any of you, frankly, can know the relief you're seeking in this declaratory judgment based on this language. I don't think you can, frankly. I think it's massively vague, and I'll tell you why. I voted, as Legislator Williams has said, for Act 2009-155. As a matter of fact, those who were on the board at the time will know that I was one of the strongest supporters of that law, okay? So I certainly think the law is binding and is a good law, and agree with the law to this very day. But I have yet to see the county executive violate the law. So I don't know what you're suing about. I don't think the county executive's done one thing to violate the law. So here I am, a supporter of the law, someone helped draft the law, someone that voted for the law, hasn't seen the law violated in any way by the county executive. What do you need a declaratory judgment for? Just want an opinion? Want a judge to come down and say, let me give you your opinion? I know there's some differences in interpreting the word proceeding, okay, between the county executive, maybe the county, I guess the county attorney, maybe the county executive, maybe the board. There's some dispute over one word. You're suing over one word? Give me a break. I mean, I voted for this, okay? Most of you didn't. You weren't even here. I voted for the law. I know exactly the intent of this law, okay? And I have yet to see this law violated by anybody in this government, and yet you want to go to court to get an opinion, declaratory judgment about this law. Legislator Williams said to ensure that it's binding law. It is binding law. You don't need a declaratory judgment. It's the law. Now, we can debate what the law means. We can debate what the law means. The word proceeding, which is a big roadblock here. I think some of my friends who think it means one thing are wrong, but that's fine. You could think I'm wrong. Let's have a debate about it. But what the heck are you suing about? I mean, this one's really ridiculous. There has been no violation of this law by this county government. So you're going to court to ask a judge to say a law is binding that everyone thinks is binding. Can you explain that one to me? Doesn't make any sense. I mean, I can understand the ANC one. I know there's a current pending action. Even the last one with the bus routes, at least I get there was a dispute over the budget. But this one word in a law, you're running to court to get a judge to opine on the law when I don't even think there's a dispute. There's a difference of opinion between some people in the government on what one word means, and you're going to go to court over this? Give me a break. I mean, you're not even serious with this one, folks. This is not even serious. I mean, some of these other issues, I understand. County executive, the board voted for X, the board voted for X, and the county executive Y, I get that. But you don't have that here. You have some people disagreeing with one word in a potential law, and that's just absurd. So I hope you're going to vote no on this. I can't imagine there's 9 legislators that have reviewed this resolution and think it's a good thing. And if you did vote for this, I'll be shocked that 9 people would vote for this, because you have nothing to sue over. No one's violated this law. What are you suing about? No one's getting up to tell us what you're suing about. I don't know. It's absurd. This one should go down, and if you vote for this, it's very troubling for the future of this county. Someone could bring a lawsuit over a couple of people disagreeing at a committee meeting over one word. Think about it, folks.
Thank you, Mr. Mazzano. Other members? All right. Let's just make some quick clarifications. Ms. Perez.
Thank you, Mr. Chair. Everybody's been standing up and arguing about whether or not we should litigate, whether or not we agree to disagree, and whether or not it's a sad date or so forth and so on. Yeah, it is a sad day, but it is more likely embarrassing. And it looks like we're going to have more embarrassing days like this when we, as the Board of Legislators, cannot agree to work together or cannot agree to disagree without ending up in court. It is very difficult as a new legislator, and I'm not sure if my new colleagues will agree with me, to be put in a position where we will be in court more often than in meetings trying to do the county's business, trying to do what's best for our constituents. As far as number 9 goes, Act 2009155, listening to both sides of the aisle, it was voted unanimously, so I do agree with that. And it disturbs me when we cannot have public discussions without resulting to litigation. The same thing goes for resolution enforcing the LWC Chapter 167 for the capital projects, where it is in the county charter, Chapter 167, any physical public betterment or improvement or any preliminary studies and surveys related thereto, the acquisition of property of a permanent nature, the purchase of equipment for any public improvement or betterment when first erected or acquired. I would really hate to see myself in a position where I could not have something delivered from my district because we cannot agree on something like this. I want to make it very clear that I am here to do the business of the county and that I'm here to do what's best for my constituents. I am not, it will not be a rubber stamp for anyone. I will be loyal to my constituents, and I will do what I believe is right for my district and, again, for my constituents. We have several discussions, both openly and privately, about this, and at the moment, although I don't fully agree with some of the statements, at the moment, I am going to support these resolutions because I believe that it is in the betterment of my constituency. But I know that we have many more to come. And with that means that we're going to have many more litigations to come. So I want to make it very clear that, again, any of these decisions, I'm not going to go ahead and just make them to be part of any one side, any one party. I'm going to make my decisions. I'm going to vote my conscience, and I'm going to vote the way that is right for my district. So with that being said, I want to make my position clear for tonight.
Thank you, Ms. Perez. Other members? All right, let's just do some quick clarification. This particular resolution, as people are, I'm just struck by from individuals' perspectives, I'm not being able to understand or read the acts that we have in front of us. We have Act number 155-209, which states clearly it's an act setting forth the policies and procedures which must be utilized by Westchester County in furtherance of the commitments established by the stipulation and order which settled the federal litigation commenced by the Anti-Discrimination Center for Metro New York. It is the intent of the County Board of Legislators that this act clearly reaffirm the statutory powers and duties of the Westchester County Board of Legislators. There is nothing that has there is nothing, and I guess people will be surprised at it. There's nothing that says the county executive has violated this act. No one has said that. No one's made a statement of that. What it says is that the county attorney shall not commence any proceedings. And what we did in the meeting of the Committee of the Whole was say that we need to sit, work, and listen to all of our sides, listen to the administration, understand their perspectives before we take any action. And our attorney, who works for us in Westchester County, said he was filing an action without the approval of the Board of Legislators. And that was the real concern for all of us. And we had a discussion at the meeting, nice public meeting about it, and said that was the case, right? That was it doesn't matter. At the end of the day, that's what the discussion was about. That not to say not to file an action. We asked specific questions. Our attorney told us we had 60 days to file a notice of appeal, is what our attorney told us. There was no rush. We could have deliberated and had the discussions that all the members here seem to want to have. And I think that makes sense. And have those discussions. We didn't need to have it that day, on that Thursday. And some of that was because all members could not be present for that particular meeting. And to say, hey, let's wait until Monday to have a discussion further about this issue. And the next day, an appeal was filed. A notice of appeal was filed. Although we were told that we did not need to do it for 60 days, filing a notice of appeal. So there was no protections for the county that was lost. So the county executive's name has not been mentioned in this particular discussion about this particular item. It was just talking about the procedures as far as the ADC lawsuit is concerned, and our work with our attorney, and the rights of every legislator here to have those discussions and to deliver.
Point of information?
Yes, Mr. Mazzano.
Mr. Chair, about 3 times now, I think you have badly misrepresented comments by our county attorney. I'd ask you to please make your own comments and don't misquote.
Mr. Mazzano, you are out of order.
You're not, no, I'm not. You are out of order misquoting the county attorney using that microphone. That is out of order.
Mr. Mazzano, you are out of order, all right? At this particular point in time, the county attorney, we have the videotape. We'll be happy to present it to members. They could go and look at any time. They could go look at the streaming right now, and they can see clearly that what we had a discussion about was the filing of notice, right? And they're noted, not any details, by the way, because that would have been done in executive session as we said it needed to be done. And the information and the vote from the committee of the whole did not bind the county board to anything other than saying, hey, let's wait until the Board of Legislators as a whole can make a discussion, have a debate, and make a decision on the position of Westchester County as the governing authority. That just wasn't done. This particular piece of legislation will help clarify that process. Madam Clerk, long roll call vote.
Mr. Harkam.
Yes.
Mr. Mazzano.
No.
Ms. Borgia. Mr. Burrows. No. Mr. Gelfarb. Mr. Kaplowitz.
No.
Ms. Marcotte. Ms. Myers.
Yes.
Ms. Perez.
Aye.
Mr. Ryan.
Yes.
Ms. Shimsky.
Aye.
Mr. Smith.
No.
Ms. Spreckman. Mr. Testa.
No.
Ms. Williams.
Yes.
Mr. Williams.
Yes.
Mr. Chairman.
Yes.
Approved 9-8. Item 5308 from the Committee on Rules is a resolution authorizing the chairman of the board to seek declaratory judgment regarding local law 2012-6 A and C modifications.
Mr. Harkam.
Thank you, Mr. Chair. Again, I will be brief. This one is one of those ones I think is clear-cut. This board, after actually many years of deliberation, finally agreed upon A&C reform. Those reforms were passed, and regarding the composition of the Board of Acquisition and Contract, and quite frankly, the composition of the board, as stated in the new law, was not honored. So we felt it was, some of us felt as legislators before this action was formally brought before the committee, was important to bring because votes on certain contracts, actually totaling tens of millions of dollars in county contracts, could have been at risk had somebody sued over the composition of the board voting for those contracts. And quite frankly, we felt it was a step urgently needed to protect the taxpayer.
Mr. Kaplan. Thank you, Mr. Harkam. Sorry.
Mr. Chairman, thank you. I'm going to be supporting this one, and my comments to start won't seem that I am, but in the end, I'm going to wind up at that spot. Well, I should go through the standards. One, is there a specific remedy that was sought, issue to be litigated? Yeah, we had the issue of mandatory versus permissive referendum. Two, is it cost effective? We were told, and so far it's been done voluntarily, and it's been done using staff. It's pretty cost effective, no cost. Three, appropriate policy, pursue appropriate remedy, and did this board actually discuss and vote? I come to this with clean hands. I voted for the A&C reform. We all come with clean hands because whether you voted for it or against it, the board, in best democratic fashion, voted for A&C reform. And so we have specific policy. We got to discuss it. That's in the good old days when we would go through committee and actually have legislation that would go through committee and discussion. The problem, sorry, in the last piece, did we exhaust all reasonable legislative options? We got to a point where it wasn't a matter of compromise and discussion. It was mandatory versus permissive. It was some very specific actions. In the old days, I guess you go out back, take a big stick and try to club each other over the head. It's not what we do. That's where the third branch of government comes in. This is maybe the classic case for, one could say the poster child for. The problem I have with it is that why are we here tonight on June 4th being asked to approve litigation that was filed how long ago? I don't even have the date. Why are we here after the horse is out of the proverbial barn, down the street, actually had its career and went to stud, and now we're trying to name the darn horse? You can't close the barn door. You can't mistrust the process. You got to come to us first. And the problem I have is if any individual legislator, i.e. Mazzano, believes that it's appropriate and from all accounts it is possible for an individual legislator to sue, okay, that's fine. But when the chairman of the board and the vice chairman of the board, who have dual roles, as legislators and also officers of the board that we've all voted for, represent themselves as chair and vice chair, and haven't come to the full board for the imprimatur, for the permission, then it looks again like it's a rump effort where simply after the fact we're trying to justify it. Sir, ladies and gentlemen, trust the process. Democracy, try it. Try the committee structure. It takes a little bit longer, and maybe it's a little bit less linear, but it gives us all as representatives a chance to represent the 950,000 people of Westchester County. When you rush off and sue, and yes, you've won, and congratulations, and that's good, and I happen to agree with the outcome, and I supported the law, but why are we here tonight, again, in essence, trying to approve? Are we trying to provide an opportunity for the monies to be paid for this individual, so it's no longer what was indicated was free, but maybe there's going to be some compensation? Well, we all need to know that. We didn't even have a chance in any committee to discuss this, except, again, Legislator Shimsky kindly allowed for some time last week. We need to, before the fact, have this discussion, unless there is an overriding time deadline that precludes, on the balance, having those discussions. Maybe I'm the only one, I guess I am. But I think that the procedures of this board, both in spirit and in law, mean something, and to represent my district as we all want to, and therefore represent the county, we need to make these decisions together in majority fashion. That's the way it's done. So I'm going to support this because it hits all the standards, but I would urge you, and it's going to be discussion certainly when we get to the special item, that in fact that was a case study and where it did not occur. In this case, fool me once, shame on you. Fool me twice, shame on me. This is the first time, and obviously at this time we have no choice but to clean up the mess. We do have an opportunity on the second one to, as a board, take a full stand.
Thank you, Mr. Kaplan. Other members? Madam Clerk, unless there's objection, members will just take the prior law roll call vote for the approval of the item. I'm sorry, Mr. Kaplan. Full roll call.
Mr. Harkam.
Aye.
Mr. Mazzano.
No.
Ms. Borgia.
Yes.
Mr. Burrows. Mr. Gelfarb. Mr. Kaplowitz.
No. No. Do I get two?
Ms. Marcotte.
You said
You
were
did.
gonna
You started.
Mr. Kaplowitz, Madam Clerk, Mr. Kaplowitz, again, please.
Mr. Kaplowitz.
Aye, thank you. Thank you.
Ms. Myers.
Yes.
Ms. Perez.
Aye.
Mr. Ryan.
Yes.
Ms. Shimsky.
Aye.
Mr. Smith. Ms. Spreckman. Mr. Testa.
No.
Ms. Williams.
Yes.
Mr. Williams. Mr. Chairman.
Yes.
Approved 10-7. Item 5311 from the Committee on Rules, a resolution authorizing the chairman of the board to seek declaratory judgment regarding the laws of Westchester County, Chapter 167, additions by the county board to capital projects.
Mr. Harkam.
Thank you, Mr. Chair. Perhaps this action, more than any other, really strikes to the heart of the conflict over the separation of powers that's going on right now. To have listened to Legislator Ryan discuss the budgetary process, the separation of powers, and the obligation that we as legislators have in the formulation of budget. Certainly nothing has been more vexing or more frustrating to certain members of this body as to the stalemate regarding capital projects passed by this board. And quite frankly, again, being told time and time and time again, we're not due them, take us to court. You know, the notion of negotiating after something is already lawfully passed and perhaps overridden a veto, you know, that time is passed. The negotiation time is at the budget table. It's not after the law is passed. So, quite frankly, I think this is one of those ones Again, the goal is clarification and closure, regardless of whose side that falls on. Maybe it falls in the middle. However that falls, we need clarity, we need closure. Certainly, this makes a whole bunch of the other ones go away, however this comes down. So I think this is an incredibly critical piece for clarity and closure from legal perspective, certainly from the role of separation of powers from this legislature. And, you know, I'll be quite candid that should we not prevail on this, you know, this legislator will really be tempted to pack it in October and take November and December off when we should be doing the budget. Because this goes to the heart and soul, I believe, of why I'm here and what I'm doing as a legislator. So thank you, Mr. Chair. So moved.
Thank you, Mr. Walker. Mr. Kaplowitz.
Chairman, I will speak next, and thank to the clerk. I was just testing her voting prowess and appreciate that. And long day, I apologize for the miscue on that. And I appreciate the opportunity to follow. I don't think any of us can take that as an invitation or a license nor anything. I, for one, I think the members, certainly majority in Legislator Harkin's district, do not want them to pack it in under any circumstance because we've got a lot of work to do, and a valuable member of this board for sure, as we all are. Mr. Chairman, I would ask that this item be recommitted in the following fashion. I don't believe that all reasonable legislative options have been exhausted here. And there's clearly, if in fact there's a path that doesn't allow for, and a wall that doesn't allow for us to get through it, then that's why, as in ANC reform, there was a necessity to go to the judicial branch. Here, however, I've listened carefully to the discussions that took place on the floor tonight, in legislation, in budgets of past, and all the rest. And I think, sir, we are within inches of an agreement. We're talking past each other. The legislature correctly in November and December adds to the budget. We have three budgets, right? Special districts, capital, and the operating budget. And we have the right to add to all three of those. I know it, Legislator Myers knows it, Legislator Alvarado and Wishney and Swanson and all the rest, and as chairs and all of those who sit on and have sat on budget appropriations intuitively know it. And we clearly have the right to do that. And I don't think the administration is disagreeing with that consideration. In fact, they've even come up with the famous Roger Maris asterisk that goes next to that, is in the book, and notice with the scarlet letter that, yes, this was added by the legislature, but there it is. But then from that point, I then listen to all the legislators again who then concede, and Mr. Ryan did tonight as well, which it then has to go through the planning board and vetting process and discussions with the different department heads, but doesn't have to meet a May 1st deadline. In fact, because we get to add ours during the November and December period. So if the administration is willing to also meet us at that point, then we have the ability to add. We've done it. It's our fingerprint. The addition's in there. If we then concede, it has to go through the various, then get back onto the main track of capital projects, which all projects have to go through. I'm not sure what the disagreement is here. Substantively, I certainly don't think we have to hire counsel to go to court to ask the judicial branch to figure out what the process is. They're going to punt it right back to us and say, you guys figure it out. We're the third branch. We're not going to figure out the budget process. You've been doing it for, I don't know, 1683 and beyond, and however you print it and it looks like. Mr. Chairman, I'm not willing to concede that there's a role for the judicial branch. Let's put everybody in the room, including the administration at the highest level, county executive or representative, and let's ask the question. This is what we see. We want to add it. We believe we can add it. And then we concede it has to go through the main channel of processes. Do you agree that, in fact, it can be added? And, in fact, it then goes through those main processes. If the answer is no, why is the answer no? Let's see if we can compromise. If the answer is yes, we don't have a crisis of government. We've now checked this one off, and we've solved this as a problem, and we've saved counsel, and we can save them for the next litigious matter that eventually comes before us. And there's no need, I think, here to have that litigation. So, again, we hire counsel tonight. The vote goes that way. I'm not even sure what we're asking the courts to do, except punt it back to us and say, you guys figure it out. That's why we hired you. I still believe we got hired for a reason, and I'm not willing to concede that we should quit or get out of here. I'm willing to concede that we got to take the jacket off, roll up the sleeves, and come to some compromise on this. We have not exhausted all legislative, executive options. This is the poster child for that necessity and an opportunity. I've had offline discussions. I know Mr. Ryan's worked hard on this one. Let's go a little bit further and see if we can. If at the end of which it breaks down and there's a litigious issue, we'll go to that at that point, recommit it, and let's see if we can't put a little bit of elbow grease into this and come up with a solution and show the people the threat's there, but we in fact aren't going to hire counsel on this one item.
Thank you, Ms. Kaplitz. Other members? Mr. Williams.
Yes, Mr. Chairman, I wish that that there was an agreement, but there isn't. I mean, we have projects that's been in the capital projects for the last 2 years, and they're still sitting there. And we thought we had an agreement last December during our budget process, when we did accept the representations from the administration that these kinds of things would not continue, that we would try to work toward reaching a solution. And not only reaching a solution, I thought we reached a solution at that point. And I think many of us voted on the last budget, the last operating budget, with the understanding that some of the things that were in that last budget was based on a compromise that we had reached, only to find out that that was a one-sided compromise and that the other side was never really intended to be followed. So I wish that we did have a compromise or some kind of a solution, but for 2 years projects have languished, have not been done. There is no indication whatsoever. I don't know if people have had private discussions, but there's no indication, at least that I know of as a legislator, that there's been any attempt to comply with the rules or comply with the law that says that the Board of Legislators have a right to make additions. That is a fundamental part of our legislative prerogative and legislative actions. And it's not something new. It's been done on this board probably since this legislature was in existence. And so for us to sit here and believe that somehow or other there is an agreement and we are going forward with getting declaratory judgment in spite of there's an agreement, that is just simply not true for those who are listening. And I want to make sure that that is clear, because if there was, I think most of us would have known about it. Having 2 years have projects sitting there not being moved. And I don't think the administration is actually, I mean, I think they're clear. The administration has been clear in its position, very clear. Position is that as a Board of Legislators, you don't have a right to make additions to the capital budget unless you get approval prior to making those additions. That's been their position consistently. Our position has been, we know that, and I think Legislator Ryan explained this over and over and over again, that our position has been that we know that there might be a process of which the other departments go through, but as a legislative branch, the right to make additions is part of our legislative prerogative to do. And that for us to compromise that, or for us to surrender and say, okay, we're giving up that right to do that, to make additions, we would have been changing perhaps, and those who have been on the board for a long time, who often give us a history lesson, I ask you this: which history lesson can you give us that says that the Board of Legislators does not have a right to make additions to the capital projects at any time during the budget process when we are considering the budget? Which history lesson says that? I mean, I'd like to hear which either rule, law, processes that ever has been enacted or followed by this board that says we don't have a right to make additions to the capital project. I don't think there's such.
Thank you, Mr. Williams. Mr. Ryan.
Mr. Chairman, before we vote, I would just once again urge every legislator in the chamber to cut right to the chase on this one. This is about your understanding and your acknowledgement of our powers and responsibilities, our rights with respect to the proposed county budget during that period when it's in our hands, and specifically our work that is accomplished in the Budget Committee leading up to the December 1st B&A action that produces the memorandum of proposed changes. There's a lot of other good issues that have been talked about, when we discuss this in particular, but I'm going to set those aside for a moment. Those are small, those are minor by comparison. This is about you standing firm, Democrats and Republicans. Throw those labels out the window. We are the legislative branch. Has nothing to do with Rob and the people on his team. It has to do with our understanding as to what our rights and responsibilities, our power and authority is with respect to the proposed budget consisting of the county proposed budget consisting of those parts we've been discussing tonight. In particular, the capital projects budget. For those of you who will vote, who are still considering voting no because you think there's more to be done, we all know that I think everyone approached this with an open mind. I like to think that. But there was a coming together of the administration and both sides of the aisle on this. The legislators that were available to go to that meeting went. If you weren't able to be there, I know that there were other things that you had to consider. But the legislators that were available to go went and participated in the conversation. And I have to think from my notes and my recollection that all the opinions, all the points of view came out. I know I did the best I could to articulate, how I felt about it. Jim was there, I think Gordon was there, and they contributed to the conversation as well. I don't think that there was, to my best I can recall, it was a lengthy meeting. We weren't dealing with a short period of time where the ideas and thoughts and what have you weren't expressed. I think everybody had that opportunity. And there was an important additional party in the room, and that was bond counsel. And bond counsel listened, and I know in the case of the legislative input, they were hearing some of that for the first time in a different context. They may have heard it kind of, abstracted out of context before, but now in the context of the full discussion, they were hearing it in a different way. That's at least was expressed to me. But the thing is, we have had that coming together. Nobody was absent. Rob was there, and his team was there, and members of this legislature, both sides of the aisle, were there. And in terms of the viewpoints that needed to get out, no one was absent. They all got out. I believe we have our answer. A while after that meeting, because bond counsel was sent off on this charge, which I gather I understood, but they were to kind of determine what they had heard and give us some indication as to how they felt about the whole thing, and whether or not they would sign off on this stuff when it got to their point in the process, which is very important, essential. Not just very important, it's an essential part of the process. And we did get a communication back from the administration, and basically it was a reminder. Board, we're rapidly approaching May 1st, and you're reminded that you need to get your projects in, or something to the effect. The point of the memo was that you're under that process in the charge. That process that we know is specific to the executive branch and the departments and the agencies that are overseen by that branch. We were basically told that's an important date, And further, bond counsel has informed us that if an item is not hasn't legitimately gone through the process, they can't possibly sign off on it in a way in which it could move forward or could in fact be included in our budget for the ensuing fiscal year. The message was very clear. But the funny thing was, I sat there as I read this memo, I said, you know, who on the Board of Legislators would even expect that bond counsel would sign off on something if it didn't go through the proper process? None of us. I wouldn't expect that they would do it. The chairman, I bet you he wouldn't. Jim probably wouldn't. This gentleman wouldn't. She wouldn't. He wouldn't. None of us would. But the thing that was missing from the memo was an acknowledgement that there was a part of the process that was ours. And should we choose to exercise, once again, our power and authority, our rights and responsibilities under the Charter, to move an item through that process, then it was legitimate. It was properly in a position to be included in the budget for the ensuing fiscal year, and it would in fact be an item that bond counsel could sign off on. That's what was missing in that memo. And so it disappoints me that we have an answer. I take it at this point, unless I see a sign, and I have no problem with Jim on the other side of the aisle on this, because through the minority leader, he, as he expressed to me that day, I think we can all come together on this, because we understand it's about our branch, our independent, co-equal branch. What? Let's see how it goes now. But I think that those are the things that need to be kept in mind here. In my view, it's different, and also in my view, I think we have our answer. Because there was no other document that arrived, at least in letter shape or email or whatever, that I was able to read that basically said, everybody's kind of rethought this. Legislature, you are in fact right. We had absolutely no business trampling on what is properly, within your domain.
Thank you, Mr. Ryan. Mr. Manzano.
Thank you. Follow up both Legislator Ryan, Legislator Kaplitz's points. Legislator Kaplitz said that we're talking past each other. Well, I certainly agree, and Legislator Ryan's comments, I think, back that up. Pretty sure that Legislator Ryan and myself fully agree about what's legally proper on the capital budget process, okay? For the most part. Maybe we have a minor difference, but 95%. And yet, I think he's voting yes to this, and I'm voting no, and let me explain why, okay? I have no idea the position you're seeking on declaratory judgment if I vote yes to that. Is it the position that I agree with Legislator Ryan? I don't know. Doesn't say. I don't know what you're seeking from the court. How could I vote for this? I know my position. I know Legislator Ryan's. I know some other people on this board's positions. I know in our caucus, we don't all agree in every aspect of the capital projects process, and I imagine that's the same on the Democratic side. So on this declaratory judgment, the relief you eventually seek, I might agree with, but I don't know. How could I? Doesn't say what declaratory judgment relief you are seeking. Now, I certainly think when the board adds capital projects belongs in the budget book. I agree with legislators on both sides of the aisle on that. There are several projects I mentioned earlier, Spring Lake Pool, I voted for LaPorte, I voted for the Miller House and others that I think the administration should have acted upon. So there's common ground on this issue. And it's kind of a shame, frankly, that this thing is so poorly drafted that we don't have bipartisan support for it. This is a lousy product. I don't know what you want a declaratory judgment for. How could I vote for it? Meanwhile, Legislator Ryan and I agree on the capital projects process. We agree. And we're voting differently because this is vague. It's vague. It should be better drafted so that I know what you're seeking for. Because there's some projects that have gone through that I have some trouble with. I have a bond counsel opinion and I have a county attorney opinion that says that on some of these projects did not go through all the normal process under the charter for capital projects. That's a problem for me. I need to understand better the declaratory judgment you seek. So You put me in an impossible situation. You're forcing me to vote no, when to some degree I agree with friends on the other side of the aisle on these capital projects. I think you're making a mistake here. You had a chance to have a bipartisan vote on this, and I have to tell you, I've told the leadership in the other side of the aisle that we could be bipartisan on this one, but you didn't draft it properly. It's not a good product. I don't know what you're suing for. I don't know if you're suing for the position I have that members on our side of the aisle could agree with you on. So I think you made a mistake here. I have to vote no, unless you recommit this and clarify the relief you seek. And I think you should recommit it, because I don't even think you know the relief you seek, because it's so vague, this resolution. So anyway, this is quite ironic. On many of these projects you're upset about, I agree with you on, but I can't vote for your resolution because it's so poorly drafted. And that's a mistake. When you could have sought a bipartisan support for this item, and you blew it.
Thanks, Mr. Mazzano. Other members? Ms. Marcotte.
Thank you, Mr. Chairman. Oh, sorry. I wasn't going to speak, but I just wanted to say this, because I agree with a lot of what has been said here this evening, and I certainly agree with Legislator Williams. I'm sorry, I disagree, and I wanted to point this out because he repeatedly says that he was told that the legislators can't add capital projects to the budget. I don't remember anyone ever saying that. I think we all agree. Everyone in this room, even the administration agreed. The legislators can indeed add projects to the capital budget, without a doubt. Here's my problem. We're a charter county. We have to follow the charter. It's our guidebook, it's our playbook. Everything we do has to come from what's in that charter, and it tells us what to do and how to submit a project, and it gives us date certain. And I think, to me, the most troubling about this lawsuit you're going to litigate, when you had the capability in your very own possession to simply make an amendment to the charter. But instead, what do? You added a law in December that completely and totally contradicts and conflicts with what's already written in the charter. The county attorney agreed, he opined that it contradicted. We never even discussed it. We just added a law that added another date. So now we're going to go to a judge and say, what do you think? The judge is going to look at this and say, well, there's so many dates here. The charter says May 1st, but then you added law 2011, was it 209 in December, that added another date that says 60 days after the project was submitted to the budget. Planning board has to opine. What is it? Is it May 1st now? Is it February 1st? You've got contradictory dates. It doesn't make any sense. The simplest solution, in my opinion, my very humble opinion, you had the ability to make an amendment to the charter, and I think it's something we all could have agreed with. No one ever said the legislators can't add projects, but the charter says you have to follow the process after you add the project. So if you add the project in December, you're still bound by the project set forth in the charter. Now there's contradicting dates, which is all very interesting. So I don't know, to me it seems like it would have been so easy to solve this. Instead we're going to litigate. I'm not going to be voting for this, obviously. Thank you.
Mr. Ryan.
Chairman, just a point of clarification. The section that we're concerned about, this section 167-101, was not added in last December or December before that or the December before. I mean, this is a long-standing part of the of our charter that deals with the county budget, and so you've been able to go there for years and years and years and find out exactly what it is that we're capable of doing and how we have to go about it. I think my colleague is referring to if I need to be corrected, fine, but I think it had to do with the legislature's concern that the administration get on with the process of dealing with items that the legislature properly put into the budget for the ensuing fiscal year. And once you got to that January 1st date, there was an expectation on the part of the legislature, representing nearly 1 million people, that certain processes would then kick in in a timely fashion so that the item just didn't languish on the vine and die. I'm pretty certain that's how that amendment came about. But setting that aside, not even talking about the process that we all have understood over the years has to take place, even before there was an amendment where that was expressly written out. So just set that aside. The process
Section 167-101, in that section of the charter, that's a long-standing process.
Thank you, Mr.
Clarify
Rudd.
briefly?
Ms. Marcotte.
Perhaps I wasn't clear enough, and that's probably because I really wasn't prepared to speak on this, but let me be very clear. This Board of Legislators passed in December, out of legislation, a local law that said the planning board had to opine, had to provide an opinion on the capital projects that had been, and it gave a date of February. Now, the charter also says they have to do that by May 1st. So there's competing and conflicting dates in the charter.
Ms. Rudd,
It's very confusing. It would have been so simple to have done an amendment to the charter. Take out the dates. Let's work around it. If you add something in December, maybe planning, maybe they can opine by March 1st. Who knows? You didn't try. You just changed the date. They contradict each other, and now we're going to go to a judge and litigate.
Let me just make, for point of order, one is just for clarification, the law that is being referred to was utilizing the process that was in place for many years beforehand, where the planning board would consider the additions to the board at the February meeting. That was the process that was in place. We went back, I think, 15 years of history so that we weren't going through one county executive. We wanted to make sure that we were going over a Republican and a Democratic county executive, so there wasn't a question of that. And what happened was that it was how that clarification that was being referred to came about. The point that we continue to talk about is in 167-101, and we talked a little bit earlier tonight about trying to seek clarification on a word. Well, in this case, the word is the procedures. The county attorney, and again, again, we want to make sure that we keep saying this. We have to assume, and we always should assume, positive intent. Right? So from positive intent's perspective, the county attorney has opined that the procedures require the Board of Legislators to have submitted this thing based on the capital budget process, which was for departments. Everyone was clear and said the County Board of Legislators is not a department. We went through that discussion. We've been having this discussion about this particular thing ad nauseum. It really is one of those things that we just need the clarity and closure. We also talked about the fact that, guess what? The Board of Legislators doesn't need a planning board decision. We need to submit something to the planning board, and 30 days after that, we can take action if they don't recommend anything. That's what's in the charter. So we don't need to make modifications in that, and that's one of the beauties, from my perspective, in being able to speak with the Charter Revision Commission to say clearly, I don't think that we need to do that many things. We may have to do some tweaks, but overall, the book has a lot of great information in it. It's just a matter of following it. As far as the bond council is concerned, people have in their agenda packets tonight, if they had the opportunity to look at it, notice from the county executive regarding this veto message regarding the Act 49-2012, which was for Harris Beach of council agreement. That is an act that was proposed by the county attorney, I believe, and correct me if I'm wrong, Mr. County Attorney, that suggested that Harris Beach be added in as a of council to the county regarding bond council. Well, the Board of Legislators in the committee discussions added in a line that the Board of Legislators could have a direct conversation with that. And the county executive in his veto message said clearly that that was a concern of his, and that was why he was vetoing the piece of legislation, because the law of Westchester County, the county attorney shall have charge and conduct of all the civil law business for the county of Westchester and its department. All right, that's no one is challenging that. We're just saying we wanted to talk to bond counsel directly on a specific item, specifically based on the information that Mr. Ryan brought up earlier. So again, we have that information in front of us. We know that. We know what estoppel periods are. We know that a judge, based on New York State municipal finance law, we have an estoppel period on particular pieces of bond acts where a judge, and it's very clear, it says a judge makes a determination if substantial compliance of the rules did not take effect. So it doesn't even say exactly that you had to follow all the rules, it just said substantial compliance to that. Again, we've been having this discussion for many times. I personally have had times to sit down with the county attorney and go through the budget book, and specifically through 167, specifically through that portion of the county budget where it creates the proposed county budget, proposed capital budget, and budget message shall be combined into one document which shall constitute the proposed county budget. And then 167-101 kicks in and says we can add to the county budget. So we've been going through this for many, many years. Clarity, closure. Other members? Long roll call vote.
Mr. Harkam.
Yes.
Mr. Mazzano. Ms. Borgia.
Yes.
Mr. Burrows. Mr. Gelfarb. Mr. Kaplowitz.
No.
Ms. Marcotte. Ms. Myers.
Yes.
Ms. Perez.
Aye.
Mr. Ryan.
Yes.
Ms. Shimsky.
Aye.
Mr. Smith.
No.
Ms. Spreckman. Mr. Testa.
No.
Ms. Williams.
Yes.
Mr. Williams.
Yes.
Mr. Chairman.
Yes.
Approved 9-8. Takes us to standing committees. Item 5096 from the Committees on Budget and Appropriations and Government Operations, an act to modify the Peekskill Sanitary Sewer District by the addition of one parcel of property located in the town of Portland.
Ms. Borgia.
Thank you, Mr. Chairman. This parcel had previously been a member of the Peekskill Sanitary Sewer District. It was removed several years ago and is now, this property owner is now seeking to become a part of the sewer district again. So I'd like to move that we approve this item.
Thank you, Ms. Borgia. Members on this item? Madam Clerk, a long roll call vote.
Mr. Harkam. Mr. Mazzano. Ms. Borgia.
Yes.
Mr. Burrows. Mr. Gelfarb. Mr. Kaplowitz. Ms. Marcotte. Ms. Myers.
Yes.
Ms. Perez.
I'm sorry, please. Very sorry.
Skip. No.
Sorry. Aye.
Mr. Ryan.
Yes.
Ms. Shimsky.
Aye.
Mr. Smith. Ms. Spreckman. Mr. Testa.
Yes.
Ms. Williams. Mr. Williams.
No.
Mr. Chairman.
Yes.
Mr. Harkam.
Yes.
Approves 16-1. Item 5135 from the Committee on Legislation is an amendment to the Fair Housing Law of Westchester County Human Rights Law in order to obtain full certification as substantially equivalent to the Federal Fair Housing Act by the U.S. Department of Housing and Urban Development.
Over.
Over, Mr. Ryan. Item 4879 from the Committees on Budget and Appropriations and Government Operations, a bond act authorizing the issuance of $380,000 in bonds of the county to finance capital project B0086, equipment control system upgrade, central heating, Valhalla campus, design and administration only.
Ms. Myers.
Yes, this was submitted before but had been returned to committee. It has been voted out again of committee, and the reason it had been returned was because there were no fiscal impact statements. We were able to get those fiscal impact statements, and as noted, this is for design and administration only. So moved.
Thank you, Ms. Myers. Other members on this item? Mr. Mazzano.
Yes, thank you, Mr. Chair. Speaking on behalf of the Republican caucus, we plan to vote in favor of the next four bond acts because we think it's critically important for this county to be moving forward with our capital projects at this time. And however, we did want to put one thing on the record relating to each one of these 4 bond acts. On Friday, it was dated this Friday, there was an a letter from the county executive to all the legislators. And in that letter from the county executive, while he did not veto a particular bond act, I guess this was the Invest in Kids one, that came across his desk, he did not veto it. He put an objection to the language in the bond act. And that same language that he objected to is in these 4 bond acts. And that language is, pursuant to Act Number 2011-179, no changes to contracts between the county and any agencies providing Invest in Kids funds programs are permitted without the prior approval of the Board of Legislators. It's my understanding that similar language for these items is in these bond acts. And the county executive said in his letter, while he wasn't going to veto this, the acts themselves have a purport to limit the powers and authority vested in me as county executive under the laws of Westchester County. So we want to say that we have a concern about this language as well, that the county executive raised in this letter from Friday relating to these bond acts. So we want to put that on the record. We think this language is inappropriate as well. However, we don't want to stop the progress on these bond acts. We're going to vote yes on them. However, we do want to state for the record that we think adding this language is a mistake and improper under county law. Thank you.
Thank you, Mr. Mazzano. Other members of this item? Ms. Shimsky.
Mr. Chairman, a question for Mr. Mazzano, if I might.
You may make your comment to the chair, Madam.
Okay. I'd like to know when that message was sent to all of us, because I and the legislators around me don't recall having received it.
I have a letter. I'll make a copy immediately and give it to everybody. It got to my desk. I don't know how. Frankly, I can't answer your question that well. I have no idea how it got to my desk. It was in my papers when I arrived here today, but I'll happily copy it and give it to everyone. No, not email. It was on my desk, but I'll be very honest with you. This was on my desk when I arrived. My staff could have printed it out. I really will have to ask my staff where this came from. I don't know. I got here in the afternoon, as you all know, and it was on my desk, and I read it, and that's all I know. But I will have this immediately copied and make sure it goes in everybody's box. Thank you.
And Mr. Mazzano, would I continue to suggest to the members of the administration, Mr. Oros is here this evening, an honorable member and a former chair of this board, that when there's communication that needs to go to all legislators, the appropriate people are sitting right in front of us. They will make sure to distribute to everyone so that there is not an issue like that. I believe this particular matter, Mr. Mazzano, all legislators did not receive that particular communication. Other members on the item. Madam Clerk, a long roll call vote, please.
Mr. Harcum.
Aye.
Mr. Mazzano.
Yes.
Ms. Borgia.
Yes.
Mr. Burrows.
Yes.
Mr. Gelfard. Mr. Kaplowitz.
Aye.
Ms. Marcotte. Ms. Myers.
Aye.
Ms. Perez.
Aye.
Mr. Ryan.
Yes.
Ms. Shimsky.
Aye.
Mr. Smith.
Yes.
Ms. Brickman. Mr. Testa.
Yes.
Ms. Williams.
Yes.
Mr. Williams.
Yes.
Mr. Chairman.
Yes.
Approved 17-0.
Madam Clerk, just again for clarification, again, certainly the staff members going to make sure that to bring that communication to the clerk, and the clerk will distribute to all members. Thank you.
Item 5003 from the Committees on Budget and Appropriations and Government Operations, a bond act authorizing the issuance of up to $441,000 to finance the design associated with capital project P0025, rehabilitation of the Bronx River Parkway over Bronx River Parkway to Cross County Parkway.
Ms. Myers.
Yes, again, as before, this is an act that went back to committee because we did not have a fiscal impact statement. We received that, and this is, again, for design associated with this capital project only. So moved.
Thank you. Ms. Myers, members on this item? Madam Clerk, a long roll call vote. I'm sorry, the member is not in the chamber, so.
Mr. Harcum.
Aye.
Mr. Mazzano.
Yes.
Ms. Borgia.
Yes.
Mr. Burrows.
Yes.
Mr. Gelfarb. Mr. Kaplowitz. Ms. Marcotte. Ms. Myers. Ms. Perez. Mr. Ryan.
Yes.
Ms. Shimsky. Mr. Smith. Ms. Spreckman. Mr. Testa.
Yes.
Ms. Williams.
Yes.
Mr. Williams. Mr. Chairman.
Yes.
Approved 16-0.
Mr. Williams, on the item that was just previously in front of us.
Approved 17-0.
Thank you, Madam Clerk.
Item 5009 from the Committees on Budget and Appropriations and Government Operations, a bond act authorizing the issuance of $70,000 in bonds of the county to finance capital project RB127, the cost of design of improvements of approximately 0.41 miles of Fort Hill Road in the city of Yonkers.
Mr. Tubiello, if you could just give that to the clerk to make sure that the members get it as well. Ms. Myers.
Yes, again, this is a bond act for $70,000, the cost of design improvements for Fort Hill Road, and again, it went back to committee because there were no fiscal impact statements. We received them and voted this out again. So moved.
Thank you. Members on this item? Thank you. Unless there's objection, members will take the prior law roll call vote for the approval of the item. So ordered.
Approved 17-0. Item 5013 from the Committees on Budget and Appropriations and Government Operations, a bond act authorizing the issuance of up to $237,500 to finance the design with associated capital project RB03D, rehabilitation of the bridge located at Palmer Road over the Bronx River, Yonkers, Bronxville.
Ms. Myers.
Yes, this is a bond for $237,500 financing the design associated with this capital project. Again, this is the last of 4 that went back to both committees with no fiscal impact statements. We received them and voted them forward. So moved.
Thank you, Ms. Myers. Members on this item? Unless there's objection, members will take the prior law and roll call vote for the approval of the item. So ordered.
Approved 17-0. Item 5231 from the Committees on Budget and Appropriations and Government Operations, an act approving certain financial terms and conditions of employment requiring legislative approval by law on a collective bargaining agreement for those county employees represented by Local 456, International Brotherhood of Teamsters.
Ms. Myers.
Yes, this is the collective bargaining agreement that was presented to the board a number of weeks ago. We went back and forth on this, both with the actual negotiator as well as with administrative staff. We have been assured that there are sufficient reserves for the retroactive payments, which are part of this settled contract. The retroactive raises are 3% in 2009, 3% in 2010, and 3.25% in 2011. We have been assured by our budget director in 2012 that there is money in the budget for this payout. The new contract, as negotiated, goes through 2015. In the new contract, there's no raises in 12, 13, and 14. The next raise would be in 2015 with an increase of 2.75%. Very, very importantly, there is a health care contribution within this negotiated settlement of 10% for existing employees, and for new hires, it would be 20% of the equivalent, what's it called? Equivalent,
The premium equivalent.
Premium equivalent, thank you. And it's late. And effective January 2015, all employees hired before July 1, 2012 will pay 12.5% for their health care. These workers, typically, it should be noted, make an average of $100,000 a year, and most of these Teamsters are attorneys in the county law department. I will turn this over to the Chair of Government Operations for the Government Operations portion of this. Thank you.
Thank you, Ms. Myers. Ms. Borgia.
Thank you, Mr. Chairman. As Legislator Myers stated, this is a contract that goes back to 2009. We were assured that although the retroactive raises are going to be paid out in a lump sum, that there is sufficient money in the budget for the payout. This is a small union, approximately 120 members. It basically is mostly members of the county law department, so they're not completely representative of the workforce of Westchester County. However, as Ms. Myers said, this is, there was an agreement that came to where both sides were pleased with the outcome, and it does include the contribution for the health care costs. Basically, an individual health care plan is approximately $8,000 and about $20,000 for a family plan. So for the 10%, at the 10% raise, that would be about $800 for the individual, $2,000 for the family, and then at the 20% rate for new hires, it would be double that, obviously. There was no impact to the healthcare contributions from our retirees. That the contract didn't address that. The workers typically make an average of about $100,000, as Legislator Myers suggested.
Thank you, Ms. Borgia. Members on this item. Ms. Shimsky.
Thank you, Mr. Chairman. First, I'd like to make a comment on the healthcare contribution portion of this, and then I would like to make a broader observation / objection to this contract. First of all, with regard to the employee healthcare contributions, I am certainly not opposed to healthcare contributions on the part of employees. I could live with the way this is done in the context of this contract, where the salary range among the members among the employees who are represented is fairly flat. But when we negotiate contracts with unions where there's a far greater disparity in income between the high end of employee and the low end, I'd still want to reserve the right to consider doing a sliding scale based on income. My broader objection is somewhat different from this, though. It is constructive that we have the kind of health insurance contribution from the employees that may get us back $1,000, $2,000, $2,500, depending on the employee and their family status. However, what we're talking about here as well is 12% salary increase, mostly front-loaded in past years, so most of it also has retroactive payments as well, to people in the upper end of our represented workers. We are talking about workers who make $90,000, $100,000 a year and perhaps more. In January 17th of this year, our county executive wrote an article in the New York Post in which one of his arguments was that a perceived imbalance in compensation between private sector and public sector employees is not sustainable. And he complained that, among other things, that the average salary of a private sector employee working in Westchester is about $63,000, while in contrast, the average county worker salary is about $71,500. So what are we doing? We're giving a 12% salary increase to people who are making $90,000 and $100,000. It just doesn't add up to me. It's not an inconsiderable sum of money. At a time when many of our constituents are making less than they used to, and at a time where we're going to have to deal with other county employees, some of whom, if they have children, qualify for food stamps because we pay them so little. Why are we spending money to exacerbate an imbalance that the county executive has already perceived? That's why I know that the county executive's office gets a wide berth in negotiating these contracts. I'm also pretty sure that my vote's not going to be dispositive on this, but I just couldn't do it. I'm taking a stand. I'm going to be voting no on this contract. Thank you, Mr. Chairman.
Thank you, Ms. Shimsky. Ms. Williams.
Thank you, Mr. Chairman. I'm rising also to object to the contract. Ordinarily, I would have no difficulty voting for a contract of this type. However, again, with Ms. Shimsky, I have to question why employees making $90,000 and above are receiving what amounts to a 9.25% retroactive raise representing 2009, 10, and 11, and a 2015 raise 2.75. I noted that in her explanation, Legislator Myers indicated that the budget director had indicated there was money in the budget for this payout. I seriously question where this money is coming from. As a proponent of child care monies and opponent of the increase to 35% for the parents' share, and realizing that as we speak or during the day, I received information that the county executive's reconciliation for the 2011 budget, including taking a surplus from DSS of $5.8 million in order to pay the collective bargaining agreement for the correction staff. I'm wondering if this is the same thing that's going to happen, and why are we taking money from the working poor, the benefits that they so rightly deserve and actually need to make this county continue to be a place to survive, not live well, but just survive, and giving it to union bargaining, making it part of bargaining unit contracts. And until there is specific information from the budget director about where this money is coming from, and we can be assured that this money is not being taken out of the mouths of the working poor, I would substantially object to this.
Thank you, Ms. Williams. Other members on this item? Mr. Williams.
Yeah. Mr. Chairman, I just want to make a few observations. I will vote on these union contracts on an individual basis, depending upon personally how I feel in terms of their the way they've been negotiated. But I would like to observe that in this particular contract, the employer or employee's contribution for the salary level is a lot less than the amounts that we passed under the sliding scale on the last for the non-represented management a year ago, I think, or a few years ago. And the point that I was trying to make is that while there is a 20% number in there, it is really a number that is not really realistic, because it's 20% of new hires. How many new hires are we going to have as a county? I doubt it, that we're going to have any substantial amount of new hires that's going to pay the cost, pay any significant amount of cost that will cover the costs of our health insurance plan. So, I mean, I say that to be, because I think it's important for us to look beyond the numbers that are really mentioned and look at their impacts. I think that it's, the point that Legislator Williams raised troubles me. I did not know that there was a diversion of funds from programs for the people who are our children, who are in very difficult situations in terms of child care, to pay for these raises and these contracts. I am troubled by that. I did not know that was occurring. I was prepared to support this contract, but I think I take a fundamental stand on the resources that need to be given to such as child care. And if this is how those amounts are being cut back so that this kind of contract can be delivered. I will not and cannot, in good conscience, vote on a contract like this. I really believe that there should have been another means of finding ways to pay for this, rather than taking it from the mouths of the poor and from children who really need child care to be safe. Thank you.
Thank you, Mr. Williams. Other members? Madam Clerk, a long roll call vote.
Mr. Harkam.
Yes.
Mr. Mazzano. Yes. Ms. Borgia.
Yes.
Mr. Burrows. Yes. Mr. Gelfarb.
Aye.
Mr. Kaplowitz.
Aye.
Ms. Marcotte. Ms. Myers.
Yes.
Ms. Perez. Mr. Ryan.
Yes.
Ms. Shimsky.
Nay.
Mr. Smith.
Yes.
Ms. Spreckman. Mr. Testa.
Yes.
Ms. Williams.
No.
Mr. Williams.
No.
Mr. Chairman.
Yes.
Approved 13-3. Item 5287 from the Committee on Budget and Appropriations, an act authorizing the county attorney to settle the claims of Jennifer Elliott against the County of Westchester, Robert P. Astorino, the Westchester County Board of Legislators, Kerry Oristano, and Thomas Laura.
Ms. Myers.
Yes, this was a negotiated claim between previous employee versus Westchester County, and the settlement was apparently approved by all, and so the committee voted to pass this out. So moved.
Thank you, Ms. Myers. Members on this item? Madam Clerk, long roll call.
Mr. Harkam.
Yes.
Mr. Mazzano. Yes. Ms. Borgia.
Yes.
Mr. Burrows. Mr. Gelfarb. Mr. Kaplowitz.
Aye.
Ms. Marcotte. Ms. Myers.
Aye.
Ms. Perez.
Aye.
Mr. Ryan.
Yes.
Ms. Shimsky.
Aye.
Mr. Smith.
Yes.
Ms. Spreckman. Mr. Testa.
Yes.
Ms. Williams.
Yes.
Mr. Williams.
Yes.
Mr. Chairman.
Yes.
Approved 17-0. Item 5288 from the Committee on Budget and Appropriations, an act authorizing the county attorney and the Commissioner of Finance to compromise the liability of Westchester County to pay workers' compensation benefits to a former county employee in lieu of future payments.
Ms. Myers.
Yes, again, this was a settlement that was reached, and the Finance Commissioner was able to reflect the benefit to the county of this settlement, and the Budget and Appropriations Committee voted to move this to the floor. So moved.
Thank you, Ms. Myers. Members on this item? I believe that in discussions on this particular item, Ms. Myers, that you all wanted to review the process that the county attorney's office had come up with this, and making a suggestion from a policy perspective to see how this could be utilized in more opportunities and more cases, and congratulating the county attorney's office for coming up with this particular strategy on this workers' compensation item. Ms. Myers?
Yes, that is correct. As a matter of fact, the Budget and Appropriations Committee enthusiastically reinforced the idea that more settlements like this could be achieved, because this one is favorable to the county.
Thank you, Ms. Myers. Congratulations, Mr. Meehan and your department on this particular item. Unless there's objection, members will take the prior long roll call vote for the approval of the item. So ordered.
Approved 17-0. Item 5302 from the Committee on Budget and Appropriations, an act to authorize the county's Commissioner of Finance to pay mortgage tax receipts to cities, towns, and villages.
Ms. Myers?
Yes, these were mortgage tax receipts that were received by the county that will now go out to the cities, towns, and villages for the period between October and the end of March. And while they are a little lower than the same period year ago, I believe in the Budget and Appropriations Committee believed that the cities, towns, and villages are all very eagerly awaiting this, therefore so moved.
Thank you, Ms. Myers. Members on this item? Unless there's objection, members will take the prior law roll call vote for the approval of the item. So ordered.
Approved 17-0. Under special orders, item 5334, submitted by the Committee on Rules, a resolution to authorize the Chairman of the Board of Legislators to commence a court action seeking a declaration concerning child care programs adopted in the 2012 Budget Act, which set the family share for low-income daycare at 20% and establishing the number of Title 20 daycare slots.
Mr. Harker.
Thank you, Mr. Chair. We are in the home stretch this evening. I really would like to thank my colleagues for their endurance and professionalism tonight, their decorum and everyone's courtesy. This was indeed a long meeting and a long day. However, it could be worse. We could be channeling the spirit of Legislator Abenanti, who would just be getting warmed up at this point. So, having said that, this is the last of the resolutions to consider this evening, and I meant that, of course, with all love about Legislator Abenanti. I don't want to get into the policy aspect of child care here. That's been thoroughly debated and vetted in the budget process, and that's what this resolution is about. We had a very, very thorough discussion on this exact child care policy. We had 3 public hearings, we had advocates, we had proponents, we had all sorts of folks come in. The county executive had proposed one fee, we changed it, there was a veto, we override it, it was set, that was the process. That's what Legislator Ryan alluded to. So when we speak about what specifically is the redress we want in the resolution, we want the Budget Act followed. That is the law of the land. And that's what is being asked here. Yeah, forgive me, I'm really tired. Yeah, that's what's being asked here. The other issue was raised earlier as well. You know, why did you raise the suit and then come back to the board? What opportunity was there for input? Bills were about to go out. You know, we live in a different age than we did 10, 20 years ago. Bills were about to go out, and that's why a temporary restraining order was needed, because we knew from the testimony we received how damaging these bills were, and that's why we filed before we came to other members of the board. The other issue was, well, what opportunity was there for board members for input? We did have a Rules Committee meeting on Friday, which every member of this board was invited to. People who are members and non-members. It was streamed live. It was held in the main committee room. It's still on the archive now for the public to see. So this notion that this was somehow not done in public is simply not true. I know Legislator Shimsky attended, who's not on the committee. Legislator Mazzano could not make it down, but he called in, and we actually had a very good discussion. And I think it's fair to say that you, Mr. Chair, and the Vice Chair, and I did not take much exception to what Mr. Mazzano was saying. I think there was a lot of common ground there. And again, we may fall out on different sides of the vote today, but I think one of the things that we all believed was, hopefully, if these actions, these votes are taken, perhaps other people may be more willing to negotiate. And you know, nobody in the end wants to resolve through litigation. Obviously, negotiation is the ultimate end of this. So timing was key. We needed temporary restraining orders, open meeting, online, open to all legislators. So moved.
Mr. Kaplowitz.
Yes, Mr. Chairman, I know my place. I go second, and then Legislator Williams goes, and then we've been through this. So maybe we should switch. I'll take Mr. Williams' comments, and he could take mine. Well, then I will take both of them, if you would. On the one hand, and then on the other. And perhaps it is good that Mr. Avenanti's not here, because I think steam would be coming out of his ears at this particular point. Up in Albany, he's probably rolling over in his legislative chair, because you go right to the first sentence of this resolve that the chairman of the county board is hereby authorized to commence or intervene. Well, we're not intervening because we started it, and hereby authorized to commence. It was filed on Wednesday, May 30th, and this resolution is dated June 1st, and we're at June 4th. So to say that things are backwards is without question. And I've stated it, I'll just state it for the record, the disappointment. I understand June 1, there's always a reason, there's always, people haven't lost their minds, there's a rationale. But when, you teach the kids to look up at the motto of Westchester County, and it's a scale, and there's relative weight on both sides, and you have to judge where does the weight of the evidence come down. This just continues to set a terrible, terrible precedent that legislators run off, that the chairman and the vice chair, officers of the board run off. They file lawsuits. They go to the least populated committee, of which the very litigants make up 3/4 of the members. Let's call it as it is. And then after the fact, come to the board for approval. Maybe they were more intellectually honest, the membership, the leadership, when in the ANC they just went off and pretended they didn't need Board of Legislative approval at all and never came to us. Until tonight, the veneer needed to be spread on all the various matters. For those counting at home, this is the 5th lawsuit, 2.5 times more than Mr. Marzano talked about, certainly more than I recall in many, many years. And, taxpayers, we're going to hear from them, maybe not. If anybody's watching, it's late at night, and I guess newspapers are gone and nobody reads them anyway. It's kind of disappointing because I hope all at least can see what we did tonight and can judge it. I fear that the jury of public opinion, no matter what the ruling is in the courts, the legal courts, will be far more commonsensical and more harsh, and recognize that if we can't resolve this, then just get a whole new bunch of legislators, because clearly this group just has no clue how to legislate, how to discuss, how to debate, how to compromise without compromising. This is crazy. What's particularly crazy about this lawsuit is that the board didn't even put enough money into this particular line, as it turns out. And so consequently, we're going to the courts to say, not only do we want you to intervene and take the role of the other 2 branches of government, but we want you then to magically decide how much it would cost to provide for the policy that was set. And then I guess they're going to step in, and maybe they'll just find the money in the budget. I don't even know. I guess we should just deliver the county budget to them and let them decide which line they should take it from. Maybe the golf course is doing a little bit better this year. If April's rained a lot, March was a good month. Maybe we can increase our revenue there. June is starting out okay. There's a process. Our budget staff confirmed. Commissioner can move money around within series lines. The Budget Appropriations Committee can move it from one line to another, the 200 to the 300 to the 400 series. And then the Board of Legislators, of course, ultimately, if you move it from outside the department into. That's our job, ladies and gentlemen. That's what we're supposed to do. We didn't put enough money in here. What do you expect a family to do if they've run out of money? I guess you can go into the basement and just print it up. Since, in fact, it's just imaginary money, let's just go get imaginary money. Or if we just can take it from there because it's running a surplus there and just move it over to here, well, that could be a discussion, but you don't sue, then ask for approval to sue, and then ask the courts to rule that you have to effectuate a policy that you really didn't put enough money in to effectuate, and then ultimately wind up back here with, in fact, the legislative directive to clean up this mess, because this is a mess. And it's particularly a mess, sir, because I support it and support childcare. It's one of the greatest investments and economic multipliers of human capital and dollar capital that we can invest in. And that's a statement. Nobody has to agree with me on it, but I think a lot of us do recognize that if people can go to work and have good quality child care, then they're comfortable and can go to work at longer hours, knowing their children are taken care of, and that they can then make money and pay taxes, which then gets spent, and it just keeps going round and around, and that's a good thing. That's all positive. So child care is wonderful, and when I voted, I was told it was enough money. Frankly, we didn't do our job correctly. And as chairman of budget, I'm disappointed that in November, December, we didn't have the right math. But guess what? We didn't have the right math, and we didn't put, in fact, the right dollars in. I'm not sure who sets the rate. I've heard the allegation that the county board has no role in setting the rate, that it's done in Albany. And in fact, we don't even have we have the ability to, the necessity of funding, but we don't set the rate. And I'll say to support that is that through the years, and I sat through, I guess 12 of them, when the previous county executive would tell us each year where his DSS commissioner and his department and his, his administration was coming down. In those days, they were lowering it each year. They would tell us what they were setting, and we would then fund the dollars. We would understand why they were doing it, and we would fund the dollars towards it. So there's a bit of a double treatment. I understand why when it's going up, because these are real dollars. These are significant dollars. Mr. Chairman, my pledge to the good parents who are getting lost in all this mumbo-jumbo is that whatever winds up back on these desks, and it's going to, because we're going to need to come up with some action, that I'm going to support, as I did up till now, finding the dollars and supporting what I believe is an appropriate level, and I'd like to keep it at 20% as one legislator speaking. My problem is, while I support the substance or the spirit behind this legislation and the understanding that we need to work to try to keep it at that 20 level, I recognize that, frankly, we didn't do our job. We're trying to cover our tracks. We're hiding the fact that we have completely trampled over democracy. I appreciate the fact that a legislator or two or three says we have to rush to court and we have to do it because it's timeliness. Well, that's again, and I'm just going to state it once again for the record, completely undemocratic. We have a full board here. Why are you even here? You should just go on the route of the A&C. File a lawsuit, just pretended as, you know, head of the department that you can simply come up with a short-form contract if necessary or get voluntary relief here. But don't do it as chairman of the board. Just do it as a legislator. And when you elevate it to that level, that's just not a good thing. I support child care. I can't vote for this in good conscience. It starts off, resolve. It's not even saying continue, pay for. It says authorized to commence. You already commenced it. Why do you need my authorization? You already trampled over any representative right I have. So I can't support it. It sends precisely the wrong message. And for that reason, I reluctantly have to vote no to this. But when the mess comes back here, I'm going to help be one of the players to clean it up, as we all will, because the parents should not suffer because we messed up and because we can't get along with the 9th floor.
Thank you, Mr. Kaplowitz. Ms. Williams.
Most of you know I am not a long, drawn-out speaker, and I don't speak extensively. And but I really must rise as chairman of the Community Services Committee to clarify some points. First of all, the figures that were given for the child care subsidy were based on the figures that we put in the budget last December were based on information we received from the budget director, Mr. Soul. They were not, we didn't come up with those figures. We didn't pick them out of the air or any other way. We got them from Larry Soul. So that if they were not correct, it was not our doing. We had and still do have every intention of making sure that parents who are eligible for these monies only have to pay the 20%, the 20% parent share that we voted on in December. Second of all, we did ask for DSS Commissioner to come back to us, and we asked him in February to come back to us and make sure that when he said that there wasn't enough money, that we would look at accurate figures and decide, since the 20% share did not go into effect until February, we asked the latter part of February, beginning of March, for him to come back to us to find out whether or not their projections were true and that there wasn't enough money in the budget. In fact, he agreed to do that. However, instead of doing that, they announced in April that they were going, rather than waiting for the first quarter of the 20% family share to be paid, they were going to increase and request an increase to the 35% level without ever giving us the figures to know whether or not there was actually a need to do this or not. And this is why, one of the reasons why the decision was made to seek a temporary restraining order. The letter was sent to New York State Division of Child and Family Care, and Ms. Walushka, I believe, in the Commissioner's office, sent out notice to people to send in written objections. Over 1,000 objections were filed with the state of New York. The Westchester state delegation sent a letter to Dr. Carrion expressing their concern about the increase and asking that it remain at 20%. This body, the Democratic members of this body, sent a letter requesting the same. Nothing seemed to move the state, and they made a decision to go along with the increase effective July 1. And this is one of the reasons, this is the primary reason why the temporary restraining order was sought, so that there was no mistake on the part of the committee or on the part of this legislature. The mistake was made in the administration's budget office. Okay? Thank you, Mr. Chair.
Thank you, Ms. Williams. Members on this item. Mr. Bezano.
To save a lot of time, my prior speech about litigation mistake and the wrong road to go on, I'll just say ditto for this one as well, save a lot of time. Second, I'd like to say that I think we're, in the last week or so, as Legislator Capwitz raised the issue, I do agree that we're making a mistake having the Rules Committee decide these lawsuit issues. This really should go into a bigger committee of the board. Mr. Chair, prior to this, you were doing it in committee of the whole. I thought that was the most appropriate when you did it that way. I don't think the Rules Committee is the proper committee to decide whether the board itself, all the legislators, is going to sue. I think more legislators should have impact on that than just members of the leadership. I think that's a mistake. I agree with Legislator Capwitz. I hope they'll change that going forward, that should not be the Rules Committee. It should be another committee of the board with budget, legislation, committee of the whole. I'll leave that to you, but rules is not proper. Number two, just for the record, under New York State, and very clear New York State law, there can't be a new action commenced on this fact pattern because the lawsuit that was filed last week. The only thing that can happen if this passes is that the board could be added as a party to this case, but you can't bring a new action. The prior action pending is a very clear law in New York State. You can't bring two actions on the same fact pattern with the same law. So that's the only result of this. Legislator Capwitz was asking, the only thing that could happen is the board could be a party rather than just the four legislators. Although I will point out that some members of the board may choose not to be a party, may choose to oppose what the board is doing if they think it's wrong. Some of us are voting no. Quickly, Legislator Jenkins, the chair, has mentioned about TROs earlier today, about winning TROs. I remind you that CPLR 6313, which is the authority to give out a TRO under New York State law, doesn't mention the word likelihood of success. That word is not in the statute. A judge can take likelihood of success as one of the factors on granting a TRO, but it's not mandatory. And the case law of judges that granted a TRO when there was no likelihood of success in the order is plentiful. Plentiful. Okay, so Legislator Jenkins seemed very excited for it when he said we keep winning. Getting a judge to do a TRO to freeze things until he makes his decision is hardly a win. Don't get too excited. A lot of law is left to happen on this case. Now, speaking of law, my friend Legislator Harkup said he said that this action be brought to enforce the law of the land. On this one, I understand what you're suing about. Before I complained, I didn't know what you were suing about. This time I know what you're suing about. I think you're wrong. I think you're wrong on what the law of the land is. I think when we get to the bottom of this case, we're going to see that the Board of Legislators did not have the jurisdiction to set this rate. You don't have that power under state law. So I think you're going to have a very hard time convincing a judge that you have the power to set the contribution rate under state law. I think if you look at the law, it's very clear that it's the Commissioner of Public Services. So we'll see how you do on that one in front of the judge. I think you're going to have a tough set. To just disagree a little bit with Legislator Williams, the veto message from the county executive during the budget process made very clear that the budget was $2.5 million short for child care. It was right in the veto message, and then you did the veto anyway. So to say that you didn't know, not really fair. It was in the veto message. It said that you didn't put enough money into child care. It was right there. And then you went and vetoed it, and you overrode his veto anyway, despite being on notice that you didn't put enough money in the budget. $2.5 million. So that's why I kind of call this the self-fulfilling prophecy lawsuit. You didn't put enough money in the budget. Because you didn't put enough money in the budget when you went from 20 to 35% back to 20% on the contribution, now it looks like there's not enough money in the budget in the dedicated child care lines to pay for the child care for the people who need it this year. Okay? The county executive tries to change the rate with the state so there will be enough money to give the child care to the people, and you're going to sue them for that. You created the mess by not putting the proper money into the budget. The county executive is trying to fix the mess, and you're going to sue them. Think about that. That's going to be a good sell in the court. So you got your TRO. Let's see how you explain to the judge that you didn't put enough money in the budget for child care. The county executive is trying to take actions to correct that, and you're suing him for the actions he took to fix your mess on the child care funding. Good luck on that one in front of the judge. Now, lastly, I think, like everything tonight, the answer to this is compromise, not lawsuit. Our caucus is not locked into the 35% rate. Let me state that for the record. We continue to be, we're not happy with how this issue has been handled from the beginning. We would be happy to discuss with the other side of the aisle a compromise between the Democratic legislators, some of them, I guess all of them, at 20%, and the county at 35%. We're more than willing to talk about a compromise number to make this lawsuit go away. So we're open. No one's talked to us yet since this issue began. There's been 1 minute, me as minority as anybody on the Democrats have reached out to say what is the Republican position. So let me make it clear. We are not locked into 35. We're more than willing to talk to our friends in this aisle about what this number should be. But of course, our demand will be that it's properly funded. So whatever we do, there's enough money to get to December to make sure all the people in Westchester who like to take advantage of these child care programs will have the money for those programs. So we're willing to talk compromise right now with you, even though this lawsuit already pending, making that door wide open with the Republican caucus. If anybody would like to talk to us, despite the fact you haven't yet, we'd be happy to talk to you about a compromise. Thank you.
Thank you, Mr. Mazzano. Ms. Borgia.
Thank you, Mr. Chairman. I haven't had my Mr. Smith goes to Washington moment yet tonight, so let me just say that I also vote with my conscience, act on the behalf of my constituency. I do rise to speak about this issue because this is something that is so significant and important to the children of Westchester County. I came into public service actually as a volunteer working on legislation at the state level to ensure that the children of New York State have safe, quality, high quality child care available to them. I think other colleagues have mentioned what a good fiscal investment and societal investment high-quality child care is. I also speak very personally as a resident of Ossining, seeing the most dire circumstance happen in our community a little over a year ago when a child who was in substandard care actually did die as a result of neglectful care. This situation couldn't be more serious. We have to make sure that our children, the children that we are responsible for here in Westchester County, do have the opportunity to be in safe child care situations. The fact of this increase, I've sat on the Community Services Board. I was not on the board last year when the mistake happened, however it happened, with respect to the funding. But I think the intent of the Board of Legislators was clear that they wanted the contribution to actually increase to 20%. It was at a lower number. That was the compromise position. I did go to the budget hearings and heard many, many, many working Westchester families testify about what a financial burden it would be to have an increase of up to $1,800 additional for child care on families where their incomes are in the $30,000, $40,000 range. It's a big increase for any family to accommodate an unexpected increase of that amount of money for a necessary item. So I'm very happy to hear that there is a willingness to compromise. We did discuss this in community services almost from the beginning. We started talking about this in January. We were told right from the get-go that we were told a bunch of different numbers, actually. Our chair, Legislator Williams, did pursue very vigorously the pinning down of the exact numbers that we needed, the exact deficit that was there. I am willing to accept the commissioner's numbers, and I do believe that we've heard a great deal from members of the administration that there is sufficient money in other parts of it, in fact the Department of Social Services budget, to fund this shortfall. It is critical that we do this. This is the exact reason why we sit in these seats, to take care of the most vulnerable and most needy members of our society. I think we all agree that high quality child care is imperative for the success of Westchester County, not only for our children's sake, but for our own future, for our economic future, to enable working families to be able to survive in Westchester, which fuels our economy. And this is something that we can't, this is not something that should be a political game. I think it's been very interesting, and I think it's very critical for us to talk about the balance of power between the three branches of government, but this is something that goes way, way, way beyond that. This is something that is dire, it is serious, it has real impact on our neediest citizenry, and it's something that we absolutely have to resolve, and that's why I'll be voting for this particular resolution.
Thank you, Ms. Borgia. Ms. Shimsky.
Thank you, Mr. Chairman. As far as the state's role is concerned, the state has a rule. I believe the range is between 10% and 35%. You could have anywhere between a 10% parent rate or a 35%, and as long as you stay in that range, the state will approve it. So it's not the state who dictates the percentage to us. It's part of the budget process, which means we have a voice, we clearly spoke. But since I've been following the county board, even before I've been elected, I have been absolutely amazed at the complete steadfastness and tunnel vision of this county executive to bring this rate up to 35% no matter what. And we have been talking about this for 2 years. We actually compromised this year, bringing up the rate from 15 to 20, which we knew was going to hurt some families. But we know that the money is there. The last 5 years, there has been an average surplus in the DSS budget of $15 million. We've just found somewhere in the low seven figures to give pay increases to people who make $90,000 and $100,000 a year. But somehow, when it comes time for the people who flip their burgers and make their coffee and trim their lawns and clean their houses, we can't find the money. So parents who maybe between themselves make $30,000, $35,000, $40,000 a year will have to come up with another $1,400 this year. Now, I don't know how you raise a family in Westchester County on $30,000, $35,000, or $40,000 a year to begin with, but I bet if you do, you don't have $1,400 worth of play in your budget. And I bet you don't have any trust funds or assets to draw down upon. This is going to hurt a lot of real people, and it's going to hurt some of those people very, very badly. There may be a child down the road who may be injured or killed because of this. There will be children who will end up in special education because they did not get quality child care when they were young and learning disabilities were not spotted early. We are going to have situations where parents are going to have to choose welfare instead of work. this is not going to be very good for those families at all. And it's not going to be very good for our economy, and it's not going to be very good for our county. And I appreciate the proffer of good faith by the Majority Leader, Mr. Maizano. I know he and I have been able to talk about things. I've been able to talk about things with a lot of people on the other side of the aisle. But the fact of the matter is, we can agree among us on some sort of solution to this conceivably, but I don't see the county executive bending on this. He's been digging his heels in on this for 2 years. As I've said before, he seems to dig his heels in on this harder than almost anything else. I don't understand why, but it is what it is. And I don't know what else to do to protect the families of this county than to institute this lawsuit, or else I never would have joined it. Thank you.
Thank you, Ms. Chinsky. I know that Ms. Williams called the Rogowski rule.
Yes, thank you. I just wanted to clarify something. Mr. Maizano made a point of saying that the county executive was correcting the mistake of the Board of Legislators by increasing the parent share to 35%. This mistake was not made by the Board of Legislators. I'm not sure he heard me earlier, but the figure that we received was from the budget office, the county executive's budget director. It was not a figure that was made up here. It was not made up in our budget office. It was a figure that we requested, and this was the figure we received. On numerous occasions, the Community Services Committee had the Commissioner of Social Service come forth from the beginning of the year until the latter part of April, asking for accurate figures on what actually was the money in the fund, what actually was their projected expenses, when would their first quarter figures be in, so that we could more accurately project whether or not there would be enough money. And I can tell you that every time he came with a whole entourage of his hierarchy, they presented different figures. There was never any accuracy in any of their figures. And now we know, based on the fact that they have found $5.8 million in the DSS budget to give to the corrections officers, and that they have consistently been, according to the budget director, under budget for years, that this year, again, they will probably be under budget, and while there may not be enough money in that particular account, within the DSS department, there is monies to pay for maintaining the 20% parent share. So I don't think that accusing this board or the Community Services Committee or anyone on this board of not doing their homework. We made every attempt to get accurate information from DSS and from the administration. We were met with obfuscation at every turn. So I think that the action that we took was a defensive action that we had to take to protect the children and the working people of this county. Thank you.
Thank you, Ms. Williams. Ms. Myers.
I would add one last thing onto this, and hopefully we can then call a question. You want something else too? We have gone over and over and over this, but the most compelling argument, I believe, that we have heard in any of our committee meetings discussing this is the fact that if this copay is raised, if this share is raised, we will see no applicants for child care, no applicants for this kind of subsidy. And then this county will be able to say, oh, look, we don't have anybody here who needs subsidized child care. We can get rid of this entirely. We've already seen this ploy with regards to homelessness. We see homeless shelters being closed. We see the rest of the county being told that we have no need for any of these social services. This is just one more way of getting around having to provide social services to residents who need the services in Westchester County.
Thank you, Ms. Myers. Mr. Williams. I got you, Ms. Smith.
Thank you, Mr. Chairman. I will try to be brief. I think a lot has been said, and I would not want to tax it any further. But I feel if there's anything that I feel very strongly about, and any reason that I see even serving as a legislator, is to take a vote such as this. A vote such as this. Because it's about children. When you net out all the excuses, all the obfuscation, all the misrepresentations, all the information, the bottom line of what we have to vote here tonight is about children. And it's about young children, most of them toddlers. And if you ever go into a daycare center and you see them, for those who are looking at home, those are the little ones that you see playing underground with little building blocks. They might not come from parents that have a lot of money, but they're children like your children and my children. They might not come from or have parents who are able to spend a lot to put them in expensive facilities, but they're no less deserving of being safe. They're no less deserving of being exposed to danger. And I don't care where you live. I don't care what your background is. Children in this county, regardless of where you live, ought to be something that ought to be a vote that you should be able to take without making excuses. And look, we talk about budget, and I think that there's been a lot said about, well, there's not enough money in the budget. Well, there's enough money for everything else. We have a surplus of about $17 million over 4 years. We have $2.5 million in additional state aid. We have an additional $6 million in surplus funds within budget lines. And if you look at this agenda, you're going to notice there are two pieces of requests for legislation from us to transfer monies within various budget lines around the county, which have been overdrawn. They're not shutting any of that down. Why do we shut down child care? That's not the only line in the budget that has been overdrawn. I wouldn't even get into the point of the funding, whether or not it's been funding adequately or not, because that is a side issue. The issue is we pass, and no one here in this board would ever ask a question when we pass the budget transfers each year. Why is it that we didn't shut down the program, or why didn't we shut down the line that was overdrawn? Has that ever been asked? I doubt it. We have legislation here proposed for us to do that. But for little children, and maybe they're not your children, and they're not your children, but they're somebody's children, and they live all over this county. Because if you were at the budget hearings, you've heard Portchester, New Rochelle, Yonkers, Sleepy Hollow, Mount Vernon, Mount Kisco, Peekskill, Yorktown, on and on and on. Regardless of what their race, regardless of what their ethnic backgrounds are, they are children. And we can get caught up in the middle of trying to justify where we ought to position ourselves in taking a vote. But I tell you, from my perspective, if I ever am unable to take a vote for children, no one would have to tell me. I would walk right out that door, because I would not be deserving of sitting in a seat that's supposed to be about servicing people, providing service and helping people. And I'm not going to spend any more time, because there's much more to be said about the fact that when you when you say, well, I'm going to raise a parent's share, and many here on this board probably can afford a $1,400 or $1,500. It doesn't look like a lot of money. But supposing you were making $30,000 with a family and little children, and don't you think that would be significant? It would. It is significant for many people. And it's hard sometimes when you are not in the position as someone else to see where they are. But I ask you, each one of us here, because I believe everyone who came to this legislature, no matter what party you came from, I believe fundamentally that everyone came with the intention of serving. And I believe that wholeheartedly. I don't think anyone came here with the intention of saying, well, I'm coming here just for political purposes. I believe that, and I think that if there's any reason for us to start probably looking within ourselves about what we are here for, let it be that we look toward a child. Could be our child, but for the grace of God, go I, that I'm not able to afford to pay for childcare for my child. I mean, my children are grown. Many of you have younger children, and many of you have grandchildren, and many of you have friends, brothers, aunts, nieces and nephews. Look at them when you go home, and think about that. Supposing they were in a situation such as one of these parents who will be getting in June 1st a bill that says your subsidy is being cut, and you may not be able to afford any longer to put your little child in that safe, regulated daycare environment, and you've got to leave them with somebody that you don't know what will happen to them. Supposing that occurred. I think that we come here, and we may disagree many times, but I think we have to look within the goodness within each of us. And some votes require for us to do that. I think we've got a lot of good people on this board from both sides of the aisle. I question no one's sincerity about how you feel about issues. But I ask and appeal for it that on this issue, you look within yourselves. Thank you.
Thank you, Mr. Williams. Mr. Smith.
So we will look upon ourselves to generate our 5th lawsuit of the night. This is not a vote about children. This action tonight is a perfect microcosm of everything that's been wrong with the last 5 months of this legislature. I'm a new legislator here. I've been watching the process. If this is how county business is done, God help the taxpayers. God help the taxpayers. This is a terrible, terrible situation. We have children in need. And I tell you, the people that are involved in the resolutions on this stuff and the lawsuits and everything else that goes on, all the rhetoric and all the twisting of the tails and twisting of the numbers, if they put half the effort into trying to solve this problem, we'd have the problem solved, or be a lot closer at this point in time now. I am infuriated by what goes on here. The resolutions, whose number, this number, that number, it's that person, it's not me. It's everybody else. It's everybody else. The numbers are important. These dollars are important to these families. I don't know that anybody here out of the 17 of us thinks that it's not. That's not a case. But we throw around numbers all the time. We talk about, oh, $17 million, always have $17 million surplus. Is someone going to guarantee me that we got $17 million surplus again this year? Legislator Kapowitz talked about how the legislature has done these type of issues in the past. I have no reason not to believe him. I run businesses. This is what we do in business. Government is not like a business, but I know that there's money other places in this government where we can take and allocate. But what are we going to do? We're going to sue. We're going to sue. We're not going to act like adults. We're not going to make good decisions. Sometimes there's tough decisions that need to be made. But we're not going to do that. The 35%, jumping from 15% to 35% in 1 year is way, way, way high. It's a tremendous, tremendous impact on families. On the other end, we've got a government that says, look, we need to balance these things out. You're saying that the 17 of us can't come up with the answer how to balance this thing? Legislator Williams said, and I love this, we don't deserve to be in this seat. If we can't find the money to fund this $4 million gap, and if you don't believe the numbers, so be it. But if we can't find that money in $1.8 billion of money that we have here, then you know what? We don't deserve to be in this seat. I expect a much higher level of performance out of myself and the 16 of you over the next 5 months. Let's solve this issue. Let's take care of the families. Enough with the rhetoric, enough with the talk. Let's get this done.
Thank you, Mr. Smith. Mr. Mazzano, with you.
30 seconds, I just would like to say that on behalf of the Republican legislators, while we don't agree that this litigation is the right way to go, we do agree with, I was very impressed with the words of Legislator Lyndon Williams, Legislator Borgia, Legislator Shipsky. I was very impressed with your words. We fully support the Westchester County child care programs. We understand their importance. We are committed to finding a formula that our board can support and that we can get approved through the county executive. We understand the importance of that. So we'd like to work with our colleagues on this side of the aisle and with the county executive's office to see if we can compromise on the formula. And number two, we are committed to making sure that these lines are fully funded to December so that all of these families are able to get their child care assistance. So on behalf of the Republican legislators, despite the fact we don't agree with your lawsuit, we are committed to the child care programs and look forward to working with our friends on the other side of the aisle, as Legislator Smith just said, to solving these problems. Thank you.
Thank you, Mr. Mazzano. Other members. Mr. Ryan.
Mr. Chairman, I don't know, you like to take great hope, I suppose, in some of the things that are said that are, I guess, meant to be constructive, meant to be positive. But I tell you what, you can't, and this isn't addressed to the legislature. I think it's everybody. It's upstairs too. You can't have it both ways. You can't talk about it, and you're there, and you're going to do what you can to make sure that the program is in place, or the funding is in place, or the policy is maintained, and then launch actions, launch initiatives, or to undermine all of that, or when it comes time to step up to the plate and cast a vote, you just can't arrive that night and do it. Tonight's different. Jim just mentioned, this is about lawsuits. I think before you even get to the point of lawsuit, the county executive will change from time to time, and we had it change. We have a fellow in there now who has a point of view, and he has a team that has a point of view, and I'm sure they talk about things and they make decisions about this kind of important stuff. We could be a county that is really indifferent to all of this, that doesn't give a damn about working families and single parents and kids. We could be one of those counties, but we're not. I don't think we've ever been that. But the thing is this: the county executive has an opportunity to lay out his view, his vision, his plan, and he does that. And he does it in a very formal way around the budget time, because it's also translated into dollars and cents, and he lays it on us. And then we actually, and I really believe this, I think all 17 of us come and we begin the process wanting to do the right thing. But at some point, face it, some people go down one road and some go down the other. Some people aren't as committed to program A as others might be. On the other hand, some people are more committed to program B, and other people in the legislature can't get there on that one. We all bring different takes to the different things that we're involved with, functionally, the different things that we're involved with. But the thing that surprises me is the legislature has ample opportunity to decide what the policy of this county is going to be. And so before you get to the argument like we're having tonight about whether or not you sue or you don't sue, talk it through, go back to the table, we already went through an important process. A policy, a view was put out, a budget was presented concurrent with that would fund the vision of the exec, and we took it and we made perhaps a different judgment. Well, there's going to be a winner and a loser in that process. And I think those that really support daycare and really understand the impact on families that are trying to go out and earn a decent check to put a roof over their heads and put food on the table, clothing on the kids' back, there's an opportunity to understand the importance of the programs and how we keep people employed and how we provide them with access to safe, quality daycare. And when all is said and done, if this legislature, that is the policy-making branch of the government, decides that we're going to do it a certain way, it's very understandable for months later for us to know that, well, the other branch wasn't real happy with how that came out and decided to set something in motion that would result in really a different looking program, a different looking opportunity as the year unfolds. And I think that's what, you know, when you listen out in the hallway, this is easy to understand. It's the conversation we're having. Our constituents, the advocacy community comes in, they talk about it. It's a very, very easy thing to understand. Somebody is not playing by the rules. And I tell you what, I'd like to think that we in this chamber understand what the rules are. We know that we will not always win when we play by the rules. Because there are rules for other people to follow, and if they happen to prevail, they do so. And more often than not, we accept that. The thing that I think many of us are having a tough time with is the fact that where we can accept an outcome, we're finding that the other branch is not as willing to accept an outcome, and now looks for other avenues to go down that undermine either our unanimous decisions or our decisions that are majority decisions. Well, I tell you what, I don't know whether that's playing by the rules. I don't know whether that's really how this whole thing is supposed to operate. It's supposed to be fair, and it's supposed to be a process that, you know, you go into it and you understand there can be different outcomes, perhaps outcomes that you're not going to be happy with. But if it unfolds correctly, then we can say, hey, we did the best we could. In something like this, kids are real important, and families that are trying to raise kids and care for them and stay on the job, that's real important. None of that is stuff that's tough for us to understand. But I tell you what, when this legislature, once again, we're not just kind of window dressing. We are the lawmaking, policy-making branch of this government. We don't share that with anybody else. We make the laws, we set the policy. If it's our decision that a program is going to be operated in a certain way, it's going to be run a certain way, it's going to provide for certain needs that we've determined collectively are out there, and then we play by the rules, we make the decisions, and we wrap things up, then quite honestly, we should enter that next fiscal year watching the program unfold the way we tell it. And if somebody sticks their nose into it and pulls the carpet out from our collective efforts, I think that's wrong, and we have a right to be upset about it. The question I guess I'm going to ask, which might be tonight more rhetorical, anything else 10 after 12, is what do you do after you've done what you're supposed to do as the legislative branch and you're still getting it put to you? What do you do? Throw up your hands, or do you end up putting an item on tonight that not everybody in the room is going to agree with? But if we don't agree with it, then throw it the hell out. And what are we going to do collectively as a legislature, both sides of the aisle, to make sure that the decisions that we make as a majority, because not everything is 17-0, but we respect the fact that some of these things that aren't 17-0, 13-4, with 12-5, whatever those majority decisions are, that those are the decisions that stand. And we don't have supposedly our partners in this process, when you look at 8 and 9, looking for ways to undermine the majority decision of the board. So what are we going to do, and when the hell are we going to start doing it? Because we can't continue on this way, come back into this room time and time again, knowing that we've had the blocks put to us again, and the thing that's on our desk has to do with going into the court. You can't keep doing this. We all understand that. Even people who have voted already tonight and supported some of these things know that you can't continue to do this. This is not the answer. But maybe the answer's got to be, if the suggestions have been made tonight, work together on this stuff, then goddamn it, maybe we got to come together to do that. I don't see it yet. So I'll be impressed when I start to see it. I don't see it yet.
Thank you, Ms. Ryan. Ms. Perez.
Thank you, Mr. Yeah, turn off the mic. This is one of those moments where I have to stand up and defend my constituents, especially being the children. In my district, some of my own neighbors, some of the single mothers who work 2 jobs to try to provide food and shelter and clothing and medicine for their children. When they go to work, they want to make sure that they are dropping off their child in a safe facility. They want to come back and find their child safe and sound, just the way they left them. Some of these mothers are working jobs where they're making $7 an hour, $8.50 an hour, barely enough to pay for their expenses right now. Raising this 35% is going to force them to quit their jobs and go on social services so that they can take care of their children. They have expressed these concerns to me. They have called me, they send me emails, they send me letters, they talk to me when they see me coming in and out of my own home. When it comes to the safety of a child, I refuse to cut any corners, and I refuse to take any chances. We cannot, absolutely not. I know numbers are being thrown around, fingers are being pointing at one another. We cannot make this a political issue. This is a safety issue. And for some of these children, this is literally a life or death issue. I mean, one of the items here on this agenda is concerning about a child who was killed in an illegal babysitting operation. So we cannot look at this as there has to be a winning side and there has to be a losing side. These are children we're talking about. It might not be our biological children. Some of them are, some of them are not, but it takes a village to raise a child. So we need to be able to make a very, very conscious decision in doing what is right for these kids. And I am always going to support the children. I just wanted to make my point very clear.
Thank you, Ms. Perez. Other members? All righty then. I'm gonna minimize the list because it went to 2 pages on the things that were flying back and forth. Let me say this. I think in hearing all the comments and the passion from every legislator, we're all angry. And I'll tell you why I'm angry. Because last year, we took the time, well, we actually did it from the 2 years before when the rate was proposed to go to 30%. So we put on the agenda. It was an item I put on the agenda, as a matter of fact, and other members joined. I can't remember who it was, so I don't want to misquote anybody, to say, let's do the New York City parent share at 30%. And in community services last year, Legislator Williams had an outstanding meeting with the Department of Social Services during the budget cycle, where the Department of Social Services, we were going to enact policy, as Mr. Ryan just pointed out, that said we will make it 35%, or 30%, I think the number was, 30% with 18% cap on income like New York City, because everyone forgets about the 18%, they just talk about the 30% part. And we said, let's do that. And we worked with the Department of Social Services, and they convinced us not to do it. They convinced us. They said, no, do not do that. Parents will get hurt. Children will get hurt. Families will get hurt. Daycare centers will get hurt. We shouldn't do that. And we compromised at 20%. And as Legislator Williams talked about, there have been 4 different sets of numbers that have come from the Department of Social Services through the Budget Director. Now, the Budget Director works for us. He's one of the few people in the Charter that actually works for both the County Executive and the Board of Legislators. We can't trust the numbers. I will tell you I will tell every legislator in here, I will tell the world, I've said it so many times, our budget staff, I trust more than our budget director. One, because the former budget director works for us. Olivia Rhodes has more experience in the Department of Social Services because that's where we got her from under Chairman Ryan. I will tell you, when they say that the numbers are X, I believe them. Now, there was a $2.5 million shortfall in the county executive's veto message that he presented to us in December, in December. But on May 26th, my birthday, thank you so much, right? It said we got the child care community block grant allocation, which was $2.4 million more than was budgeted. There is no shortfall. So we can make up numbers all we want. And I understand that, we always challenge the numbers, and we always challenge our numbers. I don't know why that is, right? Again, we have 3 members of our budget staff that have the collective experience that are 100 years between those 3 members, between Bob Bolin, the consultant, Ann Reisner, the former budget director, and Olivia Rhodes. I don't understand when we question our budget staff's numbers, when we have to go out and look, and members have said this to me before, and they say it looks like we're playing gotcha. Yeah, we are playing gotcha, because that's half our job, but we keep finding errors by these people that claim to be the experts. And whether it was a $166 million deficit, which didn't appear, or a $100 million deficit that didn't appear, you know what? I don't think we got to stop questioning our numbers and be confident in it. Last year, in 2011, the first quarter report from our budget director indicated that the Department of Social Services child care line was going to be $2.2 million short. So the department, as they're allowed, transferred $1 million inside of their department because they thought they were going to be short. Lo and behold, at the end of the year, and we just got this report today, obviously, right? Not only were they not short $1 million or $2.2 million in child care, they actually were under $675,000. So the number that they projected was fictitious, right? It might have been a conservative estimate if we want to be kind about it. But we need to stop doing this nonsense about saying the numbers are there or not there. The budget director walked into us and told us there's a $5.8 million surplus projected for the Department of Social Services. Even if it was a $4 million shortage, which it's not, they have money in their department to cover the money. We're not even going to get to the part about the department request by charter that we still don't have. That is an issue, because that's another problem that we've been talking about for the whole year, where we should have gotten the department request so we could actually see the department asked for $10 million, the administration only allowed them $8 million, and we could say, oh wait, you guys caused your own shortfall here. So we've got to stop taking this kind of thing on, and I'm really annoyed at that part from us, because we question each other's numbers here, and again, 3 people in our budget staff, 4 when we count Kabibo, right? That 4 people watch over a $1.8 billion budget, $1.69 billion budget. And they've been able to maintain that and come up with the numbers that make sense. You know, we from a perspective, and it was asked earlier, why was action taken? Well, we got the notice, and, you know, we were at our last meeting, I want to say it was May 21st, that was our last board meeting, and we got the notice at 6:35 at night from George Oros that said that we got the information from New York State Office of Children and Family Services that it was stamped in by the Department of Social Services on May 17th. And we got it during the board meeting. Because you know what, Mr. Kaplis, you're right. If we had that information that night, we would have definitely had that on, because it was one of the 18 things I thought that we should be dealing with. But Mr. Harkin, being the leader that he is, said, wait, we should wait until we hear from the state on this particular item before we move forward in trying to protect families. Because they already received notices that they were going to go, their fees were going to increase. And they already gave notice to child care centers that they were going to take their children out. Or they were already given notice by child care centers that you can't have your child here because you owe us money already. Yeah, that is an emergency. And yeah, whether it's in arsoning and unlicensed childcare where a child died, or in my district, before it was my district, where we had children scalded under Department of Social Services care, or whether we had 30% parent shares that got down to 10% because there was problems in our child care system that was brought together. Yeah, it's very, very annoying. And yeah, you know what? The rolling up the sleeves, the compromise, we did it already. It just needs to be executed now. And saying that in one line out of your $1.69 billion budget, in that one line, it looks like we're going to be short, that you made up the number. And then we find out when we ask the question from our budget director, you know what? You guys said you guys put a number in the consolidated plan that you sent to the state, which was one number. You put a number in our budget, which is a second number, for the same child care community development block grant fund, which it ended up that you got $2.5 million more, $2.45 million, let me not round up. That's where we are. And it's very annoying. It's very frustrating. It's very frustrating for all of us that we take the time to be in committee meetings, work hard with members of this administration that are the professionals, come up to a solution, try to execute that position, and you know what? It was 2 weeks, let's give it 3 weeks, in January, after the budget was approved, that said we're going to run out of money in October. And the answer is, we should have done what we said to do from the very beginning. You know what, I could say disingenuous in a lot of ways, but that's disingenuous. To say that the numbers are going to be magically made up and by October or November, we're going to run out of money if we don't take the action I said to do 2 months ago. That's the winning and losing part that Mr. Ryan alluded to earlier. That shouldn't be winning or losing. It should be about the children, and I don't think there's any member here, not one member here, that doesn't support that level of investment. And the answer that can't keep coming back to us is, well, you all should find the money. No, that's why there's 5,000 employees, and all of them get paid a lot more money than us to make sure that those things are getting executed as professionals. So again, I think that we work through compromise. We always are open to continuing to talk. We always keep going through that process. But in this case, they have enough money in their department to make sure that there was not one child hurt. And this administration's approach, as Legislator Mize, Chair of the Budget Appropriations Committee, has stated, has been the same. Anytime they have a situation come up, they try to pull a plug. And whether it was for mental health centers, whether it was for homeless shelters, whether it was during our ANC legislation, the ANC lawsuit, where there was a TRO that was issued, and they said we have to cancel all the contracts for IT because the Board of Legislators is holding them up. Meanwhile, this week we just voted on, I don't know, 5, 7 different contracts. One was open from 2010. That's the decisions that the administration is making. To say, I'm going to hurt somebody instead of moving forward. Because quite frankly, that's why, and we want to give credit where credit is due today, the administration said we're not going to move forward on an appeal of the TRO on child care. That's what the administration said. Yeah, you know why? Because you look like an evil, mean, cruel, vicious person saying, yeah, we're going to try to appeal the money that we already had out of our $1.7 billion budget, when in front of us tonight, although it got over, was a $19 million transfer from a mistake that they made last year that we're going to revisit again. And then you also talked about shorting, I guess, for raises and contract raises, not just the $5.8 million out of last year's budget, but again, saying that you did not budget, you didn't budget for raises that you know you were negotiating. You know what? It's enough. It really is. And yeah, it's very frustrating for all of us to deal with this nonsense. And I agree with you, Mr. Smith. It's nonsense to have to deal with this every day. You have the fight, you have a vote, you win, you lose, you keep going. Madam Clerk, long roll call.
Mr. Harcum.
Aye.
Mr. Mazzano. No. Ms. Borgia.
Yes.
Mr. Burrows. No. Mr. Gelfarb. Mr. Kaplowitz.
No.
Ms. Marcotte. No. Ms. Myers.
Yes.
Ms. Perez.
Aye.
Mr. Ryan.
Yes.
Ms. Shimsky.
Aye.
Mr. Smith.
No.
Ms. Spreckman. Mr. Testa.
No.
Ms. Williams?
Yes.
Mr. Williams?
Yes.
Mr.
Yes.
Approved 9-8. Item 5355 from the Chairman of the Board, resolution appointing County Legislator John Testa, representing Westchester's 1st Legislative District, as a member of the Westchester County Parks, Recreation, and Conservation Board.
Before someone tries to recommit this item, it's 12:25 at night. Mr. Testa, pursuant to the laws of Westchester County, I make a recommendation, it has to be approved by this board. The reason I put this on directly as opposed to having it go through Appointments Committee is because we have been without representation at the Parks Board as Mr. Harkin resigned that particular position. I guess that was the last meeting that we got the official notice, but we wanted to make sure that we were able to push and make sure that Mr. Testa's appointment could be effective as quickly as possible for this particular item. Unless there's someone that wants, Mr. Williams.
Yeah, I just want to rise to support my colleague, Mr. John Testa's appointment. I think he'd be an excellent park board member.
End on the kumbaya.
Ms. Shimsky.
Thank you, Mr. Chairman. As Chair of the Appointments Committee, I wholeheartedly concur. I've gotten to know John. I'm going to keep this real short. I like you, John. If you want to get stuff done with a minimum of fuss, you're the guy. Have fun on the board.
Other members, you don't want to say something nice about Mr. Testa because it's 12:30 already? Okay. All right. Unless there's objection, no, we got to do a long roll call vote for this. You know, some short roll call. How about that?
Mr. Harkin?
Aye.
Mr. Mazzano?
Aye.
Mr. Williams?
Yes.
Ms. Shimsky?
Aye.
Mr. Chairman?
Yes.
Approved 17-0.
Mr. Testa.
First of all, let me just make this very quick myself since it is Tuesday now. Thank you very much. I appreciate the opportunity, Mr. Chairman, that you're giving me. I'm looking forward to following up the great job that was done by Mr. Harkin, and I appreciate that. I'll be speaking with you about this appointment in the near future. I look forward to further representing the board, and appreciate the opportunity. Thanks for supporting me.
You're welcome, Mr. Testa. I believe we are at motions, resolutions, and call of the districts. Mr. Testa led off. Anyone on motions, resolutions, call of the districts? Mr. Mazzano.
Yes. Woman that lives exactly behind my house, Marjorie Doherty, passed away. I want to put her name on the list. Thank you.
And let's see, I would like to be added to Ms. Dietrich, Jenny Dietrich. Thank you so much, Mr. Williams. And I know that Ms. Perez is going to join me on, and maybe all the Yonkers legislators would do that.
Yeah.
For Ms. Flatley.
Yes.
Me too.
Yes, I believe that you all were added to the memorial resolution that was presented already. Ms. Spreckman. That was, okay. And Ms. Shimsky.
I'd like to be added to Rose M. D'Amelia.
Very good. Other members? Okay, I just don't, and I don't want to elongate this. The letter that we received, Mr. Orles did email it to me. I guess he emailed it to everyone else. We certainly will have to have a discussion about these particular items in the future. I understand why it was not submitted with the piece of legislation, because if the county executive submitted this particular letter that is dated June 1st regarding Act 50, 2012, expressing his reasons for not signing the legislation, that would be a veto, right, as we've gone through before. So we need to really discuss this. There's not an opportunity for editorial comment from the county executive on legislation that's passed, and I know that that's part of what this particular thing is. Certainly, obviously, discussions in committee are always welcome from the administration, and they should happen then. But if there's a letter that comes and accompanies a piece of legislation, I believe that 107.71 states that clearly. It does not say the word veto has to be in it. It just has to be a letter, that written notification on the rationale for not signing the legislation. Then it has to be reconsidered by the board. So I'm sure that the county executive just wanted to say something to us, but I'm not sure what the right process would be to do that, and we need to deal with that separately. Let's all rise, because it's 12:30 in the morning, and observe a moment of silence shortly for those that were mentioned in the memorial resolutions. Mr. Harcum.
Thank you, Mr. Chair. At this time, I would move that we would adjourn and reconvene June 18th at 7 p.m.
On the motion of Mr. Harcum, the board stands adjourned.